wanting to work.
You get it again?
Yeah, I got it.
honest with you, Meg, I don't know much about it.
Unfortunately, I've been an expert.
Okay, go to laptop presentation.
This,
No, on Jeff's.
where you run out of here, I need to talk to you real quick.
Okay.
Oh, I got my baby thing.
Megan, not Megan, I'm sorry. Megan, where's my camera at on this one?
Oh, just turn it on, right down there, see where it says start video,
Okay.
click on that.
So you want that on the defense?
Turned around, just facing the
And
court.
you've already sent the jail over.
Yes.
I'm sorry, I
Yeah, if you just send them.
Listen, pull me a cord right there, just make sure I don't jerk something out of the socket. You got it? What's up with this black one? Got it? Something just happened.
Megan.
What's your phone there? Okay. When you gonna be a laptop presentation, let me know. Hi, Tom. He gets out when you run McDonald's.
Yes,
You need some money? How much is it? You want me to? We got the call too. Jake? I don't know what it wants to use.
Usually sausage and biscuit.
How's that look? So we good to go.
Have on laptop.
Hey, Megan, you want anything?
You know what? No, they can't. We have to. Most of them should be on. I do. I usually do one. Do you hear this? Melissa, yeah, you hear this? That's his laptop. If they're big, Judge, your laptop is just. Let me go. Mom,
She's computer.
yes.
Hey, we get time for that. There you go. Turn it off.
We'll see what happens. Break this loose.
All right.
Here, before we go on the record, here's what we're gonna do. We got an individual that's gonna enter a plea, we're gonna take a live plea. Then we're going to Russell County Jail dock. And then we're going to the Clinton County Jail dock. And then we're gonna go to the door and call 10 cases to come in, and those people can be sit over there, apart. And if they missed their call, then they'll go to the bottom of the list and we'll stop back to the top. I'm not gonna be able to take things out of order for attorney's day. It's just, we got too many people showing up.
Now, when you say you're gonna call 10, Judge, you want the 10 off the list.
It's gonna be off the docket, off the top.
Here, let me give you all mine.
Because we do the jail people off the regular.
They will be in that list.
This is.
We actually got a separate list here.
What they need to do, if they bring somebody in with them, they need to sit with them, you need to separate. So in other words, if 3 people come together, they need to sit in a group and separate somebody else from we've got it on YouTube, but people who show up probably got a right to open court. But we'll do it this time, we'll set a protocol coordination.
You want to handle the alternates.
Well, let's just do it, there ain't no hurry for it. So just do it.
Do it later.
Don't let me forget.
We'll just do it later.
This is the first thing.
Just run to McDonald's.
Okay, let's come to order, please.
Turned on.
Okay, the first case on the docket, Commonwealth of Kentucky versus Joseph D. Evener. This is Commonwealth. You gotta turn it. This is Commonwealth Kentucky versus Joseph D. Evner, 20 CR 0027 and 20 CR 0028. Are you Joseph D. Evner?
Yes, sir.
Okay. What are the last four digits of your social security number?
4535.
Okay, now, do you have the mask on? Do you have COVID presently? You've been tested? You can take the mask off while you stand there, okay? What's your year of birth, sir?
October 2nd, 1989.
Okay. A motion has been tendered in these two cases. It says you wish to enter a guilty plea today. Is that correct?
Yes, sir.
Okay. Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
State your full name.
Joseph David Eager.
Okay. Are you the same person named in these two indictments, 20 CR 0027 and 20 CR 0028?
Yes, sir.
Is your judgment impaired today?
No, sir.
Okay. Have you discussed this matter with your attorney?
Yes, sir.
And Mr. Sheffett, you've had plenty of time to discuss these issues with your client, is that correct?
Yes, Your Honor.
Are you satisfied with the advice of your attorney?
Yes, sir.
Okay. Have you reviewed all the evidence that the Commonwealth has against you and you believe you're fully informed about the case?
Yes, sir.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky and United States Constitution. Before I can accept a guilty plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything. You have the right to speedy trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses, and have process issued to compel their attendance. The right to appeal this matter to a higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Do you understand that?
Yes, sir.
Okay, by entering a guilty plea today, you give up those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentences provided by law. I do not have to accept any recommendation. Prior to accepting any recommendation, I will await the pre-sentence investigation report done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to give you a harsher sentence, you will have the right to withdraw this plea, okay? And your plea and proceed to trial. Now, if you'll stand to your left over here, both of you here, and Mr. Commonwealth Attorney, you go behind the podium there and tell us what your offer and recommendation is. And young man, you listen to this very carefully, okay?
Your Honor, under the charge of burglary first degree, the defendant shall receive the sentence of 20 years. And the charge of wanton endangerment first degree, he will receive the sentence of 5 years. The charge of assault first degree will be amended to wanton endangerment first degree. The 20-year sentence and the 5-year sentence under 20 CR 28 shall run concurrently for a total of 20 years. The defendant acknowledges that the victim, Flum Furl, suffered a serious physical injury during the commission of burglary first degree, which constitutes a violent offense pursuant to KRS 439.4301. Also, in a separate case, number 20 CR 27, the charge of burglary third degree, the defendant shall receive a sentence of 5 years. 20 CR 28 and 20 CR 27 shall run concurrently for a total sentence of 20 years to serve. The Commonwealth imposes probation and shock probation. The defendant shall receive credit for time served and shall pay court costs at discretion of court.
Sir, is that your understanding of the Commonwealth's recommendation?
Yes, sir.
Has anyone, including your attorney, offered you anything else for this recommendation? Has anybody threatened you? Okay, you're pleading guilty because you are guilty and for no other reason. Is this guilty plea made with your own free will?
Yes, sir.
And knowing your constitutional rights that I previously explained to you, is it still your desire to give up those rights, enter a guilty plea, allow the court to fix your punishment within the ranges permitted by law?
Yes, sir.
Do you understand that after entering this guilty plea, that any future convictions of felonies could be enhanced as far as the range of penalty under the persistent felony offender law? Okay, now you have the document there in front of you. Okay, Mr. Bailiff, you hand that over there. Mr. Shepard, you help is that your signature on the motion and offer?
Yes, sir.
Okay, the court agrees to accept the agreement. I'm ordering a pre-sentence investigation report done by probation and parole. Where are our rule days listed? Is next rule day the 13th? August what?
12.
Yeah, those are old ones there.
Yeah, I'll put you.
August 12th. So the probation and parole office will be in contact with you. Now, are y'all, you gonna, what, can you have it ready by then?
August 8th, August 12th.
August 12th, yeah. Okay, well, y'all gonna take him out this way? You gonna take him down the stairs that way? How you gonna take him? There's a big crowd out here, you know what I'm saying? I don't know whether that's a good idea or not. Yeah, you know what I'm saying? Do what? Okay, well, you need some help going out through there. Okay,
You just go down to the back stairs.
let's go down the back steps. No, it's a high profile case. There you go. Let's go to the Russell County Jail docket, please. Where is it, Russell? Russell County, are you on the line?
Yes, Your Honor, we are.
Okay. First case is Commonwealth versus Jesse Brown. Commonwealth versus Jesse W. Brown, 21 CR 005. Are you Jesse W. Brown? We're here for a pretrial conference. What are the last four digits of your social security number, please?
8111.
Okay. You're represented by Mr. Shuffett.
Yep.
Wave Mr. Shuffett so he can see you there. Okay. We're here for a pretrial conference. What do y'all, have you made any progress on this, Mr. Stockton? Or?
No, Your Honor, I don't even think we've met about this case. I will tell the court this,
we don't have you
I
on.
think I need an invitation.
I seen it on.
You sent it yesterday.
Yeah, yesterday about 1
I
o'clock.
must have accidentally deleted it. You sent it to me.
Could you get my briefcase? My briefcase, I've got.
I picked them up here on this computer for 7 minutes.
It's not on, the volume's not on,
Oh, it's not.
because the judges. Which, if you turn your volume on, we're gonna get feedback if you're in
Yeah.
the courtroom.
Maybe I thought about it.
Well, let me can I turn mine off and let him turn it on?
You can turn that one on, yeah, but then I won't be able to hear you when you talk.
We need to do that. Mr. Stockton, come up here and use this one up here if you want to, or until she finds your thing, and I'll mute my. You open that microphone up there.
You have to turn the volume on and the unmuted on Zoom both.
Okay, I've got the volume on.
It should be on.
Okay, go ahead.
Your Honor, this is a vehicular homicide case. Mr. Brown's been charged with murder. We just got the lab report back from KSP, which he had methamphetamine in his blood. I've retained Dr. Greg Davis from UK to be the toxicology expert in this case. The lab in Frankfurt is going to have to send the sample to Pennsylvania to get a quantification on the meth, and then Mr. Davis can render an opinion on the DUI. So we will need a couple of months on this case.
Mr. Shuffett?
Mr. Stockton, is there quote unquote black box evidence in this
Shuffett,
case?
what do you have to say about that?
And Judge, that's fine. Is there black box
You're muted, Mr.
evidence in this case, Judge or Jesse?
Mr. Shuffett, you're muted, I think. Go ahead now.
No. Is that any better?
This isn't gonna work like this, Josh.
You need to go try to find your link to this.
You'll need to go in another, maybe in the jury.
Yes.
Wasn't any better.
The volume was off on the computer. It's fixed now.
Could y'all hear me at the end?
Let's go ahead and do it here, since you're here.
Is there any black box video or evidence in this case?
I've not gotten that yet through.
Can you, I thought there was, or there was going
I will
to
double check. So.
Okay, well, I'm gonna go ahead and set this. I think it would be very optimistic to set it for September the 9th, but I'm gonna set it for September the 9th. I doubt very much whether.
I'll know the status, but then.
Okay, look, of course, this will fall under the reciprocal discovery order as soon as you get that information on the black box and or the level you provide it, so that you might have emotions for it as experts yourself at some juncture. So you need to probably be preparing those as soon as you can. Okay, thank you very much. Okay, thank you, sir. I need to turn that back off here.
How are we gonna do it? Because we have all these people on Zoom.
Jesse, you need to take your laptop and go into the jury room so you can.
Test. Nobody?
We can hear you.
Oh, you can? Good.
What else you need to do besides that? Okay, Mr. Brown, I guess you were able to hear that we set your next
Like I'm in good shape, man.
September the 9th, okay?
Okay. All right. Thank you.
Yeah, okay. Commonwealth of Kentucky versus Christy Crisley. If you're not involved in this case, you need to turn your camera off.
Okay.
Are you Christy Crisley? Are you Christy Crisley? Microphone must be off there in Russell County.
Yes, sir.
Okay. You're here on a motion for shock probation. The last four digits, your social security number, 9585.
Yes, sir.
Ma'am, are the last four digits of your social security number 9585?
Yes.
Thank you. Okay, is this your motion, Mr. Sheffett?
Yes, Your Honor, it is. Christie was revoked earlier in the year in March, I believe, and we filed this. She's been in 4 months approximately since her revocation. It's an 8-year sentence, and she's not parole eligible until the first part of next year. We have sought a bed at the Independence House in Corbin, and they have a bed for her next week if the court were to allow her to be released and to go there and to be placed back on probation. I think Christy is someone who has struggled with addiction for a long time and has at times progressed and at other times fallen off the wagon. And hopefully one of these times that she gets an opportunity, she's going to seize it for good. But as we all know, addiction is rarely conquered on the first, second, or third attempt.
Mr. Stockton, what do you have to say about this?
Your Honor, she was given an 8-year sentence for trafficking. She was probated after serving a split sentence. She had 5 uses for controlled substance. So in lieu of revocation, we placed her in drug court. She was terminated for drug use, for substance abuse, and also she absconded drug court. So to me, the absconding would be the thing that would knock her out of shock probation. I would be opposed at this point in time.
Your Honor, I think Miss Chrisley may have, Christie, do you want to speak?
Yes, Your Honor. Can I read what I wrote? I would like to take this time and thank you and the members of this court for the chances I have received and apologize for not seeing them through. During the time I was out, I have learned ways to be sober, but I've also learned things that have made me relapse. Although I have pre-clean time and succeeded in rehab, I've also fell short of staying clean, and I didn't acknowledge and recognize how I was slowly turning back to my addiction. However, I did learn what choices did lead me back to my addiction, and it was too late. While being in jail, I have realized some of my triggers and downfalls. I have seen how the cycle of addiction has caused me to come back to jail, and that if I keep this up, I will be dead. I do have a support system that does love me, and I'm not alone. I'm not making excuses for my actions because what I done was wrong. If given the chance to attend rehab again, I'm going to give it my all and apply the tools that were given, they give me toward my recovery. I also see how important NA meetings are and having a sponsor is. I would like to ask for a chance to go to rehab again and prove to myself and others that my story can be a success.
Mr. Stockton, when did y'all say she would be parole eligible?
She's parole eligible March of 2022. So she's got about 9 more months before she's parole eligible, 8 or 9.
What was the quantity of methamphetamine?
I'll have to pull my file.
You remember, Mr. Sheffett?
Off the top of my head, I do not. My intuition is that it wasn't a large amount, but I can't remember for sure. And Miss Chrisley, I don't want you to say.
It was great. The docket indicates it was greater than 2 grams. So
If you give me just a second, I'll have it. It was, it was only 3 grams of meth, Your Honor. The problem was, this was a search warrant that was done at a motel, I think. Yeah, at the Royal Inn Motel. She was in a room with David Stockton, located meth pipe, 2 sets of digital scales, numerous drug paraphernalia items, and approximately $1,100 in cash. So that was the reason for the 8-year sentence. There was no doubt in my mind she was trafficking, her and Mr. Stockton was. And he was given the same break, and my understanding is he's still in drug court in rehab, unless I'm correct. You may have completed rehab.
You know, drug court is a great opportunity that people have. And you have that opportunity at a split sentence. I just don't see people coming off of this stuff unless you have a long-term situation and you've already absconded once. So I think what you say, you're saying with sincerity, but I'm going to have to deny the shock probation and hope that you get the treatment that you need while you're incarcerated. Thank you very much. Thomas Claiborne.
You don't care, get his file in. Not worry about it.
Commonwealth versus Thomas Claiborne, 20 CR 0045. Are you Thomas Claiborne? Last four digits of your social security number is 0040.
Yes, sir.
You're here today on a motion for shock probation. I'm gonna put him back there and let him use Shuffits. Will you go back and use Mr. Shuffit's recorder back there, please? Back in that room. Mr. Shuffit, will you allow Mr. Cross to use your computer?
Hey, Brad. Hi, Tommy.
Okay, this is a motion for shock probation. It's your motion, Mr. Cross.
Your Honor, it is. This is a motion that the court had heard previously and overruled. Since that time, it appears there's been some additional deterioration in Tommy's medical condition. I furnished Mr. Stockton with an ultrasound report. I only got it yesterday and got it to him this morning. Said possible heart failure. Has also got liver issues. In fairness to everybody, the Commonwealth and Mr. Claiborne, I would request that the court allow us a reasonable period of time to obtain additional medicals, because Tommy tells me he's got some further tests forthcoming. And if the court could just pass the motion, and it will stand submitted once we get the additional meds in. Does that sound reasonable, Mr. Stockton? Can't hear you.
It does sound reasonable. I will just need time to respond to something. I can't respond to it on the morning of court date. I'll need some time ahead of time before court.
Well, and Tommy, you've got, do you have other tests
Wait.
scheduled soon, or when are they?
I don't want to discuss his medical condition. We're broadcasting this thing, okay? So, if y'all are not ready today, we'll set it back. He's a state prisoner, right?
He is.
We'll have it on October 14th.
Your Honor, that's fine. And if I get anything before, I'll file a motion to expedite it.
Okay.
Tommy, I'll be in touch. Thank you.
Commonwealth of Kentucky versus Allison Dean. This is 21 CR 0008, Commonwealth of Kentucky versus Allison N. Dean. Are you Allison N. Dean? Need to speak up, ma'am. Need to speak
That's
up.
me. Yes,
Okay.
sir.
Okay, we're here today for a sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, sir.
Is there anything in there that's not substantially correct?
No.
Mr. Shuffit, is there any reason this lady should not be sentenced today?
No, Your Honor.
Upon a plea of guilty to promoting contraband first degree in case number 21 CR 0047, the defendant shall receive a sentence of 3 years. Upon a plea of guilty to possession of controlled substance first degree meth in case number 21 CR 008, the defendant shall receive a sentence of 3 years. On a plea of guilty to wanton endangerment first degree 3 counts in case number 21 CR 008, defendant shall receive a sentence of 3 years on each charge to run concurrently for a total of 3 years. The sentences in 21 CR 008 are to run 21 CR 0047 and 21 CR 008 are to run concurrently for a total of 3 years and shall run consecutively to the 5-year sentence in case number 18 CR 0044. What are the court costs? Court costs are $155, and I will allow you to start paying that 30 days after your release, either on shock probation, parole, or whatever, and you can pay it at $30 a month. And any and all drug paraphernalia and contraband shall be disposed of in accordance with laws of the Commonwealth of Kentucky. Okay? Thank you very much. Jennifer Stockton. Jennifer Stockton.
Yes, sir.
This is 21 CR 0044. Are you Jennifer Stockton?
Yes, sir.
What are the last four digits of your social security number, Ms. Stockton?
538.
You're here today on a pretrial conference. You're represented by Mr. Sheffitt. Can you see Mr. Sheffitt there, Ms. Stockton?
Yes, sir.
We also have 21 CR 0012. Okay, if y'all reached any accord or agreement on this, Mr. Stockton?
No, Your Honor. Need a trial date, please.
I don't see my.
Did you bring her files? I need those to see which one she's not co-defendants with Craig. That's the ones I'm gonna try.
Yes, yeah, I believe that's 12.
Number 12, I thought it was, but I wanted to make sure. That's the one I'm gonna elect to try.
Okay, what kind of priority do you have on this versus other cases, Mr. Stockton?
I've got two or three I need to set today here in Clinton County, Your Honor. I don't think there's any real preference.
What was the offer on this?
Miss Stockton's been to prison numerous times under my watch. She's got caught trafficking both times with large quantities of meth. She's PFO first, and she's either going to take a sentence with 10 flat to the board, or I'm going to have a trial because I'm just tired of Miss Stockton being in this neighborhood.
The answer is it's 10 years flat.
10 years flat to the board. It'll be a C felony with a PFO first, or I'm going to trial.
Okay. And you discussed that with her, Mr. Sheffitt? Mr. Sheffitt, did you discuss that with her?
Yes, that's what I've talked with her about. I think Ms. Stockton got some bad information about the outcome of an evidentiary hearing in her co-defendant's case on the on not 21 CR 12 on 21 CR 44, and I have requested those tapes, and I'm going to review those. Of course, the court and Mr. Stockton were involved in those hearings and are aware of what happened. Mr. Stockton relayed to me that the court found for the Commonwealth in Tom Carroll's motion to suppress the search warrant. Ms. Stockton got the ideal from, I guess, relatives that the opposite had occurred. So that made our settlement conference probably not as productive because that kind of got in the way.
Who was the co-defendant?
Joey Craig and Stephanie Craig.
Okay. I don't recall, but.
But Your Honor, I would think this case would have some priority because the lab report in 20 CR 12 indicates over 73 grams of meth. I think that's about 6 ounces plus other drugs. So we're ready to try it whenever.
Have Craig's been tried?
No, I'm putting that out. That'll be my next case at some point in time. But 21 CR 12 on Miss Stockton's one I'm elected to try. She's in that one all by herself.
Okay, let's go out and look in September. It appears that in September, it could very well be that the case that's set for 27, 28, 29, and 30th in September might not go. Is that correct?
Well, I'm trying to locate a doctor, but if I don't locate him, I'll probably get another doctor from UK. So that's kind of where I'm at. I think I can prove that child was deceased without a doctor.
I don't want to talk any details about it. I thought there might be a plea in that case without mentioning the name of the case. Okay.
I've not heard anything back from defense counsel. So.
Okay. Well, I think that I'll go ahead and set this second in case there is a plea on that one, and then we can reset it.
That'd be fine.
Okay, so let's go to the, let's start it on the 28th.
You gonna do 2 days on that, Your Honor?
Yes.
Okay. Here you go.
Your Honor, could we do a pretrial on the 9th?
We'll do a pretrial in August. August the 12th, we have pretrial.
Okay.
I don't want to wait till beginning of September and do a pretrial if there's going to be a plea, because that would open those dates back up again. And as backed up as we are, we can't afford to pass any dates up like that. Okay, is it? Okay, well, thank y'all very much. Does that conclude what we have at Russell County? Do y'all have anybody else? Russell County have anybody else?
Your Honor, you have Burton.
No, he's continuing.
His case did continue to win.
August 12th.
Case is continued to August the 12th.
That's all we have.
Thank y'all.
Thank you.
Back now.
Jail docket. We'll go to the Clinton County Jail docket. Clinton County Jail docket. Clinton County, you're on there.
Yes.
First case is William David Cope. Commonwealth of Kentucky versus William David Cope, 21 CR 0070. Are you William David Cope?
Yes, sir.
Okay. Were you born in 1961, Mr. Cope?
Yes, sir.
Last four digits of your social security number, 3558.
Yes, sir.
You're here today for the purpose of arraignment. You're represented by Mr. Shuffett. You see him on the screen there, Mr. Shuffett, wave there.
Yes,
Your
sir.
Honor, this is a direct presentment, so I anticipate an appointment, but I haven't been appointed yet.
You're appointed.
Okay.
Okay. Mr. Cope, you have the right to remain silent. You're here for the purpose of arraignment. The grand jury of Clinton County has returned indictment charging you with criminal mischief in the first degree, theft and unlawful taking under over 500 but less than 10,000. You understand those charges?
Yes, sir.
Okay. Mr. Shuffett, have you received an indictment on this thing?
Not yet, Your Honor.
Okay, well, we have the indictment. We'll hand it into your back office back there. You acknowledge the identity of your client, waive formal reading and arraignment, enter a plea of not guilty, and reserve all pretrial motions.
Yes, Your Honor.
Okay.
Sir,
Yes, sir.
they have my bond so high that there's no way.
We'll get to that in just a second, okay?
Okay, thank you.
Okay, now,
Thank you.
next court date will be on August the 12th. What is this gentleman's bond? Pretrial, you on there? Janessa, you on there? Who's on there?
Yes, it's me. It's a $25,000 surety bond.
Okay, and with the normal conditions that he
Yes, the standard conditions.
be on a curfew, You don't
Yes.
have anybody that can sign a bond for you, Mr. Cole? They don't have to put any money up, sir.
Yes, I have someone that can sign a bond. I have him waiting just to let me, just if he can sign it, he'll come straight and sign it. He's very upstanding citizen here.
Who
He'll
is,
sign,
who is the person that's gonna sign the bond?
Brian Connors.
Yeah, Mr. Connor called me, Your Honor. I went to school with Mr. Connor. We're about the same age, and he said he would sign a $5,000 surety bond. And I told him that I wouldn't have any objection to that if Mr. Connor would do that.
Okay, I will change the term of the bond to $5,000 surety bond, but you're also be under a curfew. So you can go home, work, church, you know, you can go to the doctor. Okay?
That's fine.
Okay, and if you need to go anyplace else, you'll need to call pretrial. Ms. Janessa, do you have a number that he needs, that you need to give him, or?
We can put it on the bond whenever we send it.
Okay, well, when the bond is there, the number will be on there, and you need to call and check in with pretrial, give them the address that you're gonna be and that sort of thing, okay?
Your
Yes,
Honor,
sir.
he also needs to be present here if he makes bond on August the 9th to meet with me and Mr. Sheffield at 9:00.
Yes, sir.
August the 9th is the meeting to negotiate, and then August the 12th is the next court date. Both of them are conditions of your bond, okay?
Mr. Cope, Mr. Cope, could I get a phone number and address for you real quick?
I mean, it's 276 Kentucky Highway, 639 North. But
Okay,
I
wait
just-
just a second. You give him your phone number, Mr. Sheffield. I don't want him to broadcast his phone number over the line here.
Okay. Mr. Cope, you probably know how to contact me, correct?
I got your number.
Okay, thank y'all very much.
Thank you, sir.
Yeah, the next case is Commonwealth Kentucky versus Justin Daly.
Daily.
Commonwealth Kentucky versus Justin Daly, 21 CR 0063, 20 CR 0015, and 20 CR 0016. Are you Justin J. Daly?
Yes, y'all.
Okay, were you born in 1989?
Yes, y'all.
Last four digits, your social security number 6037.
Yes, y'all.
Okay, you're here today for a pretrial conference in 0063 and 0015 and 0016. What's the Commonwealth have to say in this case?
We typed plea papers. I don't know if the plea was accepted or not.
Your Honor, we do have a plea agreement.
Okay,
They were sent to the jail yesterday. We went over it. I assume that got back to the clerk's office.
okay, we'll pull them out there. Take a look. Wait a second. Okay, Mr. Daly, I understand that you wish to enter a plea today. Is that correct?
Yes, y'all.
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
What's that?
Is this plea freely and voluntarily given?
Yes.
Okay. State your full name, please.
Justin Joe Glenn Daly.
Are you the same person named in these three indictments that I have before me here?
Yes, y'all.
Is your judgment impaired today in any way? Is your judgment impaired in any way? Do you know what's going on here? You have any?
Yeah.
Okay.
Yes, I understand.
Have you discussed these charges with your attorney, and are you satisfied with his advice?
Yes.
Have you reviewed the evidence the Commonwealth has against you, and you believe you're fully aware of your case?
Yes.
You understand that you do not have to enter a plea today. You have certain rights under the United States and Kentucky Constitution. Before I can accept a plea, I need to know that you fully understand these rights. You have the right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, the right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charges against you. Do you understand those rights?
Yes.
By entering guilty plea today, you give up those rights, and I may consider the Commonwealth's recommendation, but I may apply any range of sentences allowed by law. I don't have to accept it. Prior to accepting the sentence, I will have a pre-sentence investigation report done by probation and parole. If I decide to impose a harsher sentence, however, you can withdraw your plea. You understand that?
Yes, Your Honor.
Okay, now listen very carefully as Mr. Stockton goes over what the Commonwealth's recommendation is.
Your Honor, in 21 CR 63, Mr. Daly will plead guilty to theft by unlawful taking of $500, over $500 and persistent felony offender second degree and receive a sentence of 10 years. He will also plead guilty to obscuring the identity of machine or other property and persistent felony degree offender second degree, a sentence of 10 years. Those two 10-year sentences shall run concurrently for a total of 10 years. In 20 CR 16, he will plead guilty to possession of a firearm, a convicted felon, and receive a sentence of 5 years. In 20 CR 15, he will plead guilty to receiving stolen property for $10,000, receive a sentence of 10 years, and the charge of complicity to arson second degree, a sentence of 10 years. The two 10-year sentences shall run concurrently for a total of 10 years. All 10-year sentences and those three indictments shall run concurrently for a total of 10 years to serve. The defendant agrees to forfeit his interest in the Winchester rifle so it can be disposed of in a manner consistent with the laws of Commonwealth of Kentucky. The Commonwealth will oppose probation and shock probation, and he'll receive credit for time served and pay court costs at the discretion of the court.
What about the weapons charge?
He's pleading guilty and receiving a sentence of 5 years. That's in 21.
So you're, all of them are together for 10 years?
All of it together for 10 years, Your Honor.
Is that your understanding of the Commonwealth's recommendation?
Yes, Your Honor.
Has anyone threatened or you or offered you anything to enter this plea?
No.
Are you pleading guilty of your own free will?
Yes, I plead guilty.
Okay. Knowing the constitutional rights that I've explained to you, is it still your desire to give up those rights, enter plea of guilty, and allow the court to fix your punishment?
Yes.
Okay, you understand that after entering a guilty plea, any future convictions will enhance the range of penalties. Okay, let me have the plea agreement here. Right to his signature. Is that your signature on there, sir?
Yes, Your Honor. Yes.
Those need to be dated. You understand? Well, I'll accept the agreement and order a PSI and have the sentencing date on August 12th, but I will tell you that I'm very concerned about the firearm situation. Now, I will want to probably hear more about that, and that'll be included in the pre-sentence investigation report. I don't know about this, but the Commonwealth's more aware of it than I am right now. So at this juncture, we'll proceed with the thing, and I'll take a look at that. Okay, thank you very much. The next case is Matthew Denny. Matthew Denny. Okay, you'll need to go back in there and use Mr. Shuffett's computer.
Sorry to disturb.
Oh, no, you're. The Commonwealth versus Matthew Denny, 21 CR 00055, 20 CR 0047, 20 CR 0076. NCR 0056. Here for pretrial conferences on all those. What do you have to say, Mr. Stock?
Your Honor, we don't have an agreement that I'm aware of, so I would request a trial date in 21 CR 55.
Okay. Now, you're not going to be able to try this case with the other co-defendant we previously set.
There's no co-defendants in any of his cases.
Oh, I thought he had a co-defendant.
No, I'm not aware of any.
Okay. Well,
Mr. Carroll represents Craig's to have a couple, yeah.
That's what I confused a little bit. Does this case have priority over the Craig case for you, or?
It does. It doesn't have priority over the Stockton case, but it's got priority over the other case that Mr. Carroll has.
How about on October 19th?
That's fine with me, Your Honor.
And Jesse, which case did you elect?
21 CR 55.
Judge, is that a case that's first on the docket or behind something?
No, be the only case on the docket.
Okay.
What was that date again? The date again?
Oh, overnight.
Yeah.
You got that. Mhm.
Okay, we can have a pretrial in this case. I guess on September the 9th. Okay, thank you.
That's fine with me, Your Honor. Thank you.
Emmanuel Fluter.
Tight little squeeze in here.
It is.
Commonwealth versus Emmanuel. Okay, guys. Commonwealth versus Emmanuel Fluter, 19 CR 0005. This case is already set for trial.
It is, Your Honor.
Okay. Okay, what, you have motions, Ms. Hunter?
Judge, we realized we need to renotice some motions if we could, for Mr. Stockton to be able to respond on the August date, because I realized we've not renoticed those since the March 2020 date, that we kind of abruptly were brought to a halt by COVID. So I realized we had not renoticed that for Mr. Stockton to have that.
What do you have, Mr. Stockton?
I just have a motion for UK, University of Kentucky Hospital, to release Dr. Nollis biographical information to me. He's no longer employed. The court's probably not aware, anytime I subpoena a doctor from University of Kentucky, I have to go through their legal department, and I never have contact with that doctor. And they never keep me informed as to the comings and goings of these doctors, as to whether they're employed or no longer employed. The last time it was set for trial, I had him subpoenaed through UK. And then the next time I tried to subpoena him, they told me he wasn't employed there. I have a program where I can find Dr. Nalla if I have his biographical information. I can confirm that I get the right one. So I noticed the motion to UK's legal department. I've not heard anything from them. So I'm just asking for an order for them to release that information to me, and it will be kept.
Okay, submit the order, submit the order.
Thank you.
Wait, you got other motions?
Yeah, I have those motions for out-of-state subpoenas to be domesticated also. I thought they were routine. I didn't think there'd be any objection to that.
Okay, we'll sign those orders. Is there anything else?
That's all I have, Your Honor.
Okay. Okay, has there been any plea negotiation more in this case? I don't want to talk about what it is.
I would just say I've submitted my final offer, and if it's not accepted,
What's the date that this is set for?
This is the last week of September, Your Honor. If you give me just one moment, I'll pull up
September
my calendar.
27th.
yeah, it's coming up quick. And if we're going to be hearing those motions on the 12th of August, I assume that there was not going to be a plea on this case. I'm going to go ahead and start getting ready.
Okay, if there's going to be a plea, it'll have to be by the 12th of August because there's just so much things to go on in this. So that's kind of a red line, if y'all understand that, okay?
Yeah.
Okay, thank y'all very much.
Thank you, Your Honor. May I be dismissed? That was my only case.
Absolutely. Have a nice day.
Thank you, Your Honor.
Yeah, Commonwealth versus Charles Hicks. We'll bring him in next, okay? Shane Perry, we're gonna bring her in next. She's the light brown. Shane who? Okay, Commonwealth of Kentucky versus Charles J. Hicks, 21 CR 0013. Are you Mr. Hicks?
Yes, Your Honor.
Have you got a chance to look at the precinct's investigation report for 21 CR 0013?
Yes.
Okay, is everything substantially correct?
Yes, sir.
Mr. Shepard, is there any reason this gentleman should not be sentenced?
No, Your Honor.
You have the signed copy with you, Mr. Shepard. Where is the signed copy? One in
The PSI? No, I don't have any. It was forwarded to me from your office.
Okay. Just make sure. It's
Yeah.
Thank you. Well, need to track. Is there any reason why this gentleman should not be sentenced in this case?
No, Your Honor.
Upon a plea of guilty to traffic control substance first degree, the defendant shall receive a sentence of 6 years probated for 5 years. The defendant shall serve 94 days in jail, receive credit for time served, released the day of final sentencing. You should pay a fine. How much the fine court cover? 155. Sir, do you need some time to pay that?
Yes, sir.
Okay, you make your first payment of $30 a month, starting 30 days from today, okay? The defendant shall obtain gainful employment within 30 days. He shall remain on active supervision until all fines, costs are paid, or until further request by probation and parole. At the conclusion of all the co-defendants' case, the defendant agrees to have any and all contraband and paraphernalia disposed of according to law. Now, you need to, I guess, you'll be released today. Probation and parole is here. What do you need to tell him?
Have him report to the basement of this building, Clinton County Courthouse, in the morning at 10 a.m.
Okay, sir, you report to the basement of the Clinton County Courthouse tomorrow at 10 a.m. to report to probation and parole, okay?
Yes, sir.
Okay, thank you very much. We'll get that release over as soon as we can. It's right here, so. Okay, I'm going to take a case out of order because we have someone that has a medical issue with us. But who is it? Cheyenne Perigin.
Did we call her code lieutenant too? Yeah.
Who are the bailiffs?
I don't know, do you want me to call her code lieutenant?
Yeah, I guess so. Up here, up here. Cheyenne Perigin. Okay, and Tina Perigin.
She needs to be here.
Okay, they're both here for pretrial conference. Y'all have agreements in these cases?
No.
Can you hear what's going on back there, Mr. Stockton?
No, I need to step out.
Yeah.
Judge, this is Adair County. We've got one here for you to see.
Okay, I'll be with you next then.
All right, thank you.
Yeah. Come on, case. There you go. Okay, this is Commonwealth of Kentucky versus Cheyenne Perigin and Tina Perigin. Cheyenne is 20 CR 0003 and Tina is 0002. What we got here, Mr. Stockton? You need to get over on the camera here. September the 9th, be on your way. Okay. Okay, now I'm going to go to, Adair County Jail. Is that Mr. Brown? Mr. Little, Liddell, Mr. Liddell.
Yes, my name's Liddell Vaughn, Your Honor.
You will, if you'll lower your camera shot there so we can get your face on screen.
There we go.
Okay. It's Commonwealth of Kentucky versus Charles Brown, 20 CR 0089, who is incarcerated in Adair County and in the courthouse here in Clinton County. Cumberland Circuit Court is meeting. We have Christy R. Brown. Are you Christy R. Brown? What are the last four digits of your social security number? Okay, and Mr. Brown, what are the last four digits of your social security number?
8162.
Okay, now you're here today for the purpose of arraignment. Both of you can remain silent. Counselor, will you identify yourself, make appearance for him?
Your Honor, my name is Liddell Vaughn. I represent Mr. and Miss Brown.
Okay. Sir, do you acknowledge the identity of Mr. and Miss Brown?
Yes, Your Honor.
Have you received the indictments?
I have seen the indictment, yes.
Okay. You waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay, Mr. Stockton?
Yes.
What's the bond in Mr. Brown's case? Pretrial on there?
$50,000 cash.
Okay.
Your Honor, we would request, if somehow we could get that lowered to 25,000 property bond, then he may have a chance of getting out, but that may be hard also.
Well, I'm not going to lower it without a reason, unless the Commonwealth agrees to it without a hearing, but we will grant you a hearing very soon. What's your position, Mr. Stockton?
Your Honor, I agreed to accommodate Mr. Vaughn on the arraignment, and then at about 12, I got a motion to reduce bond and a motion for visitation. So I would request a hearing on the bond, Your Honor.
That's fine, Your Honor.
Okay, we'll set, July the 29th. That's in 2 weeks.
Your Honor, I am out of town during that time. The original arraignment was set for that same day, and that's the reason why we moved it up to this day.
To be August 26th.
Tell me what else is on me.
And what
Did you say, Your Honor?
and for these motions. Motion. Well, this motion that you have there will probably be at the end of the docket call, probably won't be at 9 that day. So 11, what time? How long do you think your motion will take?
My motion for the bond reduction,
For visitation?
1 minute, Your Honor. I mean, just state my case and let the court decide.
Let's do it now.
Your Honor, Miss Brown is out of jail. She had been seeing the children under the supervision of the Child Protective Services, and 1 day a week at the Office of Child Protective Services. We would ask the court to allow her to continue doing that so that the children can stay connected to their mother as best as possible.
Mr. Stockton, you have a response?
I believe if I read Mr. Vaughn's motion correctly, it is the other 3 children and not the victim that he's requesting visitation.
That is correct. I'm sorry.
Yeah, I will go along with whatever social services wants to do as far as the other 3 children. I would object to her having visitation with the victim in this case.
Okay, we will enter an order then to allow her visitation with the other 3 children, subject to any limitations that might be set by the cabinet. What's your other motion on the bond reduction? You still there, sir? We lost him. Well, we'll hold an abeyance to bond reduction and enter the other order, okay?
I thought you said it for August the 26th, the bond motion.
I'm talking about for today, I hold an abeyance. I mean, I'm
Oh,
not
okay.
decide that one today. I just decided the other one as far as the visitation is concerned. And we'll hold it on the 26th at the end of the docket. Okay, thank you very much. Does that conclude Adair County?
It does.
Okay, have a great day. Thank you.
You too.
Supposed to see about social services agreed to it if you would allow it, make on with Maggie. She has surgery on the 6th.
Nobody brought that up to me. You need to have your attorney to talk to, is Maggie the alleged victim?
No.
Okay, well, you need to talk to your attorney and have him to contact the Commonwealth attorney for an agreed order. Okay, I'll sign it if they agree to it. Did you hear that, Mr. Stockton?
No, I did not hear what you said, Your Honor.
Said that one of the children is supposed to have a surgery and her attorney was supposed to bring it up, that ask if she could go and attend the surgery. And I
Yeah, he
told
just
her,
needs to submit an order.
get an agreed order with you on that.
Yeah.
Okay. Now, we
26th. No, I can't do that. No, it's real bad.
Rocky Allen Masciano, back to the Clinton County Jail.
It's gotta come.
Are you Rocky Allen Masciano?
Yes, Your Honor.
Okay, what's your last 4 digits of your social security number?
304-802059.
Okay, the last 4 digits then would be 2059. You born in 1962?
Yes, Your Honor.
Okay, you have an attorney?
Yes.
He's represented by me, Your Honor.
Okay. We're here today for the purpose of arraignment. You have a right to remain silent, sir. The grand jury of Clinton County is returning an indictment charging you with possession of controlled substance first degree. You understand that charge?
Yes.
Okay. Counselor, do you acknowledge the identity of your client received indictment, waive formal reading and arraignment, enter a plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
Mr. Stockton, you want him there on the negotiation day?
Yes, if we can have the August 9th and August 12th day, Your Honor.
August 9th for negotiation and August 12th. What is this gentleman's bond?
I believe he had a case in Cumberland County. He may be having bond violations. The reason he's committed it while he was on bond.
What's pretrial?
He has a $15,000 surety on this indictment, and then he has a $25,000 cash on the Cumberland County.
Okay, well, we'll deal with that some other day. Okay, thank you very much. Next case, Commonwealth versus Miller.
Your Honor, this is Liddell Bond. May I interrupt just a moment?
Yeah, well, I'll tell you what happened while you're gone. Your female client said that there was an issue about some surgery. And
yes.
You submitted an agreed order to allow her to attend the surgery to Mr. Stockton, and I will sign it, okay?
Okay. What about the visitation with the children? We were right in the middle of that.
I said I'm going to sign an order on that to allow them to have visitation with the 3 non-victim children, subject to any limitations that might be imposed by the cabinet.
That's fine, Your Honor. I appreciate it. For whatever reason, my computer just shut off.
It happens. You have a nice day.
I appreciate it. Thank you.
Commonwealth versus Walter Miller. Walter Miller. Are you Walter Miller?
Yes, sir.
Okay, this is 21 CR 009. Mr. Miller, what are the last 4 digits of your social security number?
7915.
Okay, you're here today on a pretrial conference on several charges. What is the Commonwealth, and also on several charges. What does the Commonwealth have to say about this?
Your Honor, we've been in negotiations. I don't think they've been very fruitful. Mr. Sheffett mentioned something about having an expert evaluate Mr. Miller.
Your Honor, that's accurate. We're in the process of gathering records for Mr. Miller in hopes that we would have some background for an expert on competency.
Okay, well, what do y'all want to do about this? Set it for another pretrial?
I guess, and if Mr. Sheffett's going to raise competency, I don't know, we could just go ahead and send him KCPC. And then Mr. Sheffett can decide if he wants to get an expert or not.
Well, if the court wants to order that's fine, but that wasn't how I was going to handle the competency issue. But
well, how long has he been in jail?
He's been in, I believe, since the occurrence of the event.
That's like telling me that was the year mom had surgery. I don't know when.
Well, January of this year.
January of this year. Well, it's July. And it costs people of Clinton County a lot of money to keep him incarcerated.
Yeah, we could set it for trial. We can send him KCPC, or we can have a bond hearing, because I would request a bond hearing before it's reduced based on all this.
I'm not going to reduce it.
Okay.
What are you raising your hand for there, Mr. Miller?
My mom's here to bond me out today.
No, that's incorrect, Your Honor. I just had a conversation with his mother this morning, and she wants Mr. Miller to stay in jail, in all candor, because of how he's acted in the past.
Okay.
If his mom's named Vicky Frazier and she's calling from Tennessee, that's who I spoke to this morning.
Okay. Well, have you had plea negotiations on this thing?
We have, and we're to the point either it's going to be a prison term or a trial. I mean, that's based on the information I just received, so.
What do you say about that, Mr. Shepherd?
Well, Your Honor, I understand that's the Commonwealth's position, but before we can proceed, I want to challenge competency.
Well, have you filed a motion on that yet?
I have not. We're trying to gather some records. His mother provided some mental health providers to us earlier in the case, and we're trying to seek those.
Okay. Set this next pretrial be November 4th. Okay. Okay. Commonwealth versus Ricky Purdue.
I need that file.
Commonwealth versus Ricky Purdue. Are you Ricky Purdue?
Yes, sir.
What's the last four digits of your social security number?
1284.
Okay, you're here today on a probation revocation hearing. What do you have to say, Mr. Stockton?
Your Honor, Mr. Purdue has a 10-year sentence for assault second degree and a 5-year sentence for wanton endangerment for a total of 10 years. He's before the court because he tested positive for methamphetamines twice or admitted to that. And also because he was involved in an assault allegedly. And if Mr. Purdue's not going to stipulate and wants a hearing, I would like to have an opportunity to try to subpoena the victim in the assault case for the hearing.
What do you have to say, Mr. Sheriff?
Look, Your Honor, we believe that Mr. Purdue's got a valid self-defense claim in the assault case. He's been arraigned in district court, has a pretrial coming up week after next. I feel pretty good about that case regarding the substance abuse. That's an ongoing issue that Ricky needs to address, and we would be looking for the court to issue an order to help him address it through his probation.
Today, on this matter, I think the district court thing will be resolved maybe by August the 12th.
I don't know for certain, but depending on what the complaining witness's wishes are, and we're certainly, I don't anticipate Mr. Purdue entering a plea to resolve it in that way.
Okay. Yeah, basically he has 2 district court matters pending, Your Honor. He's also got a criminal possession of a forged instrument that Officer Glover would need to testify. So if we have a hearing on the probation, I would have 2 witnesses available.
Okay, well, let's have the hearing on probation revocation on August the 12th.
Okay. I need you.
Thank you very much. Next case, Commonwealth Kentucky versus Stephen D. Posey.
Brad, what about getting out on bond?
Commonwealth versus Stephen Posey.
Judge, I think that's Mr. Purdue. Would the court consider a bond while this motion is pending?
I'm on Posey. Commonwealth versus Stephen Dwayne Posey, 21 CR 0060. We're here today for the purpose of arraignment. Are you Stephen Dwayne Posey?
Yes, sir.
Born in 1975.
Yes, sir.
What are the last 4 digits of your social security number?
6996.
Okay, you're here today for the purpose of arraignment. You have a right to remain silent. Mr. Shepherd, is this your client?
Yes, Your Honor.
The grand jury of Clinton County has returned an indictment charging you in possession of controlled substance first degree and possession of drug paraphernalia. You acknowledge your client's identity, receipt of the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motion.
sir.
Yes, Your Honor.
Okay. What's Mr. Posey's bond?
It's a $15,000 surety bond.
Okay, that seems reasonable. With other conditions, restrictions on it.
Yes.
You be available on August the 9th and for negotiation, and August the 12th for your next court appearance. Why, you have nobody can make a $15,000 surety bond for you?
No, sir.
Or they don't have to put any money up or anything?
Yeah. I don't have nobody got no property or nothing like that.
But Your Honor, it's my understanding that folks who are gonna sign a surety bond still have to show some ability of their.
They have to sign an affidavit that they're worth
Right.
$15,000.
Well,
I don't know. That seems. Mr. Stockton, what kind of criminal record does he have? What's pretrial have to say about this guy?
Yeah, I may confuse him with Posey. I don't know. Has he had any failures to appear, Mr. Steve Posey?
He is a moderate. He has a prior misdemeanor conviction, prior felony conviction, 0 failure in the last 2 years, but a prior failure to appear outside of those, and 2 prior crime convictions, and a sentence to incarceration.
Well, I'm willing to leave the bond at where it's at. I think, if he can find somebody, so that's a very reasonable bond since he's had a prior FTA. So, okay, thank you very much.
Thank you.
Commonwealth versus Dewar Eugene Salisbury III.
I need the plea on that.
Are you Durward Eugene Salisbury III?
Yes, sir.
This is 20 CR 0060 and 20 CR 0064. I understand that you, and also 21 CR 0065. I understand that you have filed a motion that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
State your full name.
Durward Eugene Salisbury III.
Are you the same person named in these 3 indictments I just read?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Can we discuss these charges with your attorney?
Yes, sir.
Are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence that Commonwealth has against you? Do you feel like you're fully informed?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept a plea, I need to know that you understand those rights. You have the right not to testify against you. No one can make you say anything. You have the right to speed trial by jury, right to be represented by counsel at jury trial, right to confront and cross-examine all witnesses, call to testify against you, right to produce evidence, right to call witnesses on your behalf, right to bill to matter in higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty. You understand those charges?
Yes, sir.
Okay, now I can consider the Commonwealth's recommendation back, but I can sentence you to any amount of law that is any range of sentence that is allowed by law. Prior to considering the recommendation, I will wait to the probation and parole, that's a pre-sentence investigation report. In the event that I do not accept the Commonwealth's recommendation and decide to give you a harsher sentence, I'll give you a right to withdraw your plea if you don't agree to that. What is the Commonwealth's recommendation?
Your Honor, in case number 20 CR 60, Mr. Salisbury will plead guilty to trafficking and controlled substance first degree, first offense, a class C felony. He will receive a sentence of 8 years. In 21 CR 65, charge of trafficking, controlled substance, first degree, first offense, a class C felony, he'll receive a recommended sentence of 8 years. On 21 CR 64, he will plead guilty to trafficking in a controlled substance first degree, first offense, a Class C felony, and receive a sentence of 8 years. The 3 8-year sentences shall run concurrently for a total of 8 years. The Commonwealth opposes probation and shock probation. Also, Mr. Salisbury will forfeit $422 in 20 CR 60, and he'll pay court costs at the discretion of the court and receive credit for time served.
Is that your understanding of the agreement, sir?
Yes, sir.
Has anyone, including your attorney, offered you anything in return for this plea other than what was stated or threatened or coerced you in any way?
No, sir.
You're entering a guilty plea because you are indeed guilty and for no other reason.
Yes, sir.
Knowing your constitutional rights and have explained it to you, it's still your desire to give up those rights, enter a plea of guilty and allow the court to fix your punishment within the range permitted by law.
Yes, sir.
You realize by entering this guilty plea that any future convictions could be enhanced as far as the range of penalty under the persistent felony offender law.
Yes, sir.
Okay, let me have that signature there. Is this your signature, sir, on there?
Yes, sir.
Okay. I'll accept the plea order pre-sentence investigation report, and the sentencing will take place on August the 12th. Okay, thank you very much. Thank you. We have two. Okay, the next one is, let me see. Next one is Robert Lee Smith. Commonwealth versus Robert Lee Smith, 21 CR 0072. Are you Robert Lee Smith? Were you born in 1972? You're gonna have to say something. It doesn't pick you if you don't say anything. Are you Robert Lee Smith?
Yes, sir.
Okay, thank you. Born in 1972?
Yes, sir.
Okay, you're here today for the purpose of arraignment. Mr. Sheffett is your attorney. He's on the screen. Wave, Mr. Sheffett, so Mr. Smith can see you. Okay, Mr. Smith, I'm going to read down through the charges, and you have a right to remain silent because anything you say could be used against you. I recommend that you exercise that right, okay? The grand jury of Clinton County has returned an indictment charging you with trafficking controlled substance first degree, possession of drug paraphernalia, operating under the influence of motor vehicle, reckless driving, excessive windshield tinting, open alcohol container, failure to maintain insurance, possession of controlled substance, methamphetamine, convicted felon in possession of a firearm, and be a persistent felony offender second degree. You understand those charges?
Yes, sir.
Mr. Sheffett, you acknowledge the identity of Mr. Smith, the received indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions in this case.
Yes, Your Honor.
Okay. What is Mr. Smith's bond?
$50,000 cash.
Mr. Stockton, what do you say about that?
Your Honor, I'd request a bond hearing on Mr. Smith.
Okay, Mr. Smith has a right to a bond hearing. You want to schedule that, Mr. Sheffett, we can. That he shall be available on August the 9th for negotiation of his case and be back in court on August the 12th. If he makes his bond, those continue to be conditions of his bond. August 9th here for negotiation, and August 12th for the purpose of the next court appearance. Thank you. Thank you very much, sir. We have Robert Lee Duval that is down in the jail now that has been added to the docket. Rodney Lee Duval.
Just watching case files.
Are you Rodney Lee Duval?
Yes, sir.
What is your last four numbers of your social security?
4953.
What year were you born?
10-3.
Okay, Mr. Clark, we're here on a probation revocation hearing. What do you have to say?
Your Honor, Mr. Duval has got the last case he's got pending under probation is criminal mischief first degree. On July the 2nd, Mr. Duval, according to Mr. Payne, attempted to alter the drug screen. I spoke to Mr. Payne about this case. Mr. Duval had went a considerable amount of time without any violations and had maintained gainful employment. And I asked, based on Mr. Payne's recommendation, he's already seen the SSCs lined up for treatment, that he'd be released, but his probationary period be extended, if that's all right with the court. My understanding is he can go back to work.
Are you working, Mr. Duval?
Yes, I'm appointed
Where are you working at?
for Nathan Thrasher.
Yeah, I would ask you to be under a heightened probation as far as drug test here in the near future also.
What do you have to say, Mr. Shelby?
Your Honor, no objection. That's, I think that's what we were trying to accomplish.
Okay, well, let's extend the probationary period 5 years from today, if that's an agreement. You in agreement with that, Mr. Duval?
Yes, sir.
Okay, well, we'll sign an order letting you out, and then we'll, I guess, probation and parole needs to take a very close look at what kind of additional services that he might need.
I think he's already been assessed and he needs to report to Mr. Payne tomorrow, Your Honor.
We're at here in Clinton County in the basement.
Yes, sir.
Basement is here in the courthouse, yes.
What time?
8 o'clock.
8 o'clock in the morning.
8 o'clock, you've been in the basement here. If you get out today, you've been working for 4 hours, but then you can take your lunch off at 8 o'clock, okay?
Yes, sir.
Okay. Try to straighten it up. For me. Commonwealth Kentucky versus Caleb Purdue.
It's a victim of COVID, I think.
I don't have it.
Caleb Purdue.
Yes,
Are you Caleb Purdue?
Yes, sir.
It's 21 CR 0022. We're here today for a pretrial conference. What are the last 4 digits of your social security number?
5966.
Okay, what do you have to say, Mr. Stockton, in this case? Did they just pick you up today, Mr. Purdue?
No, sir. I've been in for like 90. What was it? Like 95 days or something like that.
Okay. Two PFOs receiving stolen property and theft unlawful taking over 300.
Yes, sir.
Your Honor, we'll have a plea agreement for the court to consider.
Okay. Just waiting for somebody to tell me. Okay. A motion has been tendered that says you wish to enter a guilty plea today. Is that correct?
Yes, sir.
Currently under the influence of drugs or alcohol?
No, sir.
Is plea freely and voluntarily given?
Yes, sir.
State your full name, please.
Caleb Aaron Purdue.
You born in 1964?
1994.
1994, okay, 1994. Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney? And are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence that the Commonwealth has against you and you believe you're fully informed about your case?
What'd you say, sir? Sorry.
Have you reviewed the evidence that the Commonwealth has against you and you believe you're fully informed about your case?
Yes, sir.
You have certain rights under the Kentucky and United States Constitution. I need to know that you understand those rights before I can accept a plea. You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, right to be represented by counsel at your jury trial. You have a right to confront and cross-examine all witnesses called to testify against you, to produce evidence, a right to call witnesses in your favor and have process issues. You have a right to appeal this matter to higher court if you lose. You have a right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charges against you. Do you understand those rights?
Yes, sir.
By entering guilty plea today, you give up those rights. Now, I may consider the recommendation the Commonwealth's about to say, or I can sentence you to any term of incarceration permitted by law, I do not have to accept the recommendation. However, if I do not accept the recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Do you understand that?
Yes, sir.
Mr. Stockton, will you recite what the agreement is and see if this gentleman agrees with that?
Yes, Your Honor. Mr. Purdue will plead guilty to theft by unlawful taking or disposition over $10,000. He will receive a sentence of 10 years. He'll plead guilty to receiving stolen property over $500, receive a sentence of 5 years. The 10-year sentence and the 5-year sentence shall run concurrently for a total of 10 years. He'll serve 180 days in jail with the balance probated for 5 years supervised. He'll receive credit for time served. He'll pay restitution amount of $700 at a monthly rate of $100 a month to the Clinton Circuit Clerk to be dispersed to Michael Connor. That's all set forth in the restitution order. Restitution shall begin within 90 days from release of incarceration. He'll maintain gainful employment and pay court costs at the discretion of the court.
And Jesse, did you want to require drug court in this case?
If he's eligible, it would be a good idea, Your Honor. He's been in drug court before and he did quite well for a while. But if he's not eligible because of the time constraints, he'd have to see that.
I'd like to submit an assessment, and they can make their return.
I'll sign a referral.
Okay.
Sign a referral. Okay, but the court costs are what? 155, and you start, I'm gonna give you some time to pay that. You pay your first $30, 30 days from today, or 30 days from the date you get out. Will they get out? When will they get out?
It'll be probably a couple months after sentencing, Your Honor.
Okay. Okay, you start 30 days after you get out, you do $30 a month. You pay that. Has anyone, including your attorney, threatened or coerced you in any way, get you under this plea or promised you anything in addition?
No, sir.
Okay. You understand that by entering this plea today, any future convictions could be enhanced under the persistent felony offender law. You understand that, don't you?
Sir.
Okay, is this your signature on the document right here?
Oh, yes, sir.
Okay, I'm going to accept the plea agreement and then make a determination whether we what we do as far as sentencing. So you will be sentenced on August the 12th. Okay, does that include the jail docket? Is that?
I do have one more, Your Honor.
Who is that?
Dylan Flowers.
Okay, as you're coming in, if you're in a group, you need to sit in your groups and get as close together as you can down there. Y'all need to get close together as you can so some other people can sit on the end. If y'all are together, if you're in the same group, are all y'all in the same group? If you are in the same group, you can sit together and get close together. If you're not in the same group, get about 3 or 4 people apart. Commonwealth versus Dylan Flowers, 18 CR 0073. Are you Dylan Flowers?
Yes, Your Honor, I am.
Born in 1991.
Yes, sir, Your Honor.
Last 4 digits, your social security number of what?
4226.
Okay, we're here today on a revocation hearing. What do you have to say, Mr. Stockton?
Your Honor, he's on, got a 5-year sentence and he was terminated for SAP IOP because he had 13 absences. I've talked to Mr. Payne. I'm recommending that he go into drug court, and if he doesn't want to do that, I'd like to proceed with the revocation.
Your Honor, I've discussed it with Mr. Flowers. He's interested in drug court. I tried to get up with Barry. He's out till next week, but I think he does need to be assessed and see where we are.
I'll sign a referral to drug court and he can remain incarcerated until the termination date. And I'll do it. Okay, thank you very much.
Your Honor, would it be possible to release Mr. Flowers on home incarceration until then?
You'll have to talk to Commonwealth Attorney. We're not.
I would
Well, he
object. Your
declined,
Honor.
but I needed to bring it up. So thank you, Your Honor.
Thank you.
Does that conclude the jail docket?
Yes, sir.
Okay, thank you very much, Mr. Taylor. Commonwealth Kentucky versus Tony Albertson. Mr. Stockman sit up down here yet? Commonwealth versus Tony Albertson. CR 0004, you Tony Albertson. What the last 4 digits of your social security? 947. What's your year of birth? You gonna have to speak up?
August 14th, 1980.
Okay. Your date of free trial.
Your Honor, I intend to submit an ex parte order for Mr. Albertson. He's previously been found incompetent by this court. I don't think any circumstances have changed regarding that finding. So I'm going to ask for expert funds on that.
What do you have to say, Mr. Stockton?
He's been found incompetent several years ago at KCPC. I think based on the evidence in this case, they may change their mind. But if Mr. I would just go ahead and make a motion to have him sent to KCPC. If they find him incompetent again, we move.
Well, Your Honor, he's out of custody and KCPC is an in custody setting. I don't know if they have some type of independent contractor that can do it, outside of.
He's trying to possession marijuana, cultivation marijuana, this is unusual.
I've been a former farmer myself, growing tomatoes for years. I think anybody that can successfully cultivate marijuana, I'll be competent. I'm not going to say yes, Doctor.
Well, I don't want to say that because I put out 2 tomato plants and could keep the squirrels moving, so I don't know. Strange thing happens, huh? You file your ex parte motion, we'll set this thing. Have you had any complaints on pre-trial with this young? How many complaints are involved in this thing? Allegedly. I'm gonna ask you, Mr. Albertson, obviously you know anything about the plans.
I haven't looked, I think it was around 10 or more.
You want to set it back for September the 9th, then you can give me an order and
I'll get that order to you.
September.
I'll get the order to you tomorrow.
Okay, Mr. Albertson, you look across from me out there and don't get me in trouble. If you walk by any marijuana plants out there in the woods, just run.
Yes, sir, I will.
Okay, thank you very much. Commonwealth Kentucky versus Billy Dean Eglin. Call one more time up there.
Is there a warrant out there?
Okay, we'll make sure there's a warrant out. Chair Ayers. Humble versus Chair Ayers. Your day for the purpose of arraignment. Are you Chair Ayers?
Yes, sir.
21 CR 0058. Serious, what year are you born?
I'm born.
For the last 4 years of social security number.
201.
Your day for purpose of arraignment. You right when you south of Virginia, Mr. Shepherd. Green jury of Clinton County Attorney indictment charged with trafficking controlled substance first degree first offense and drug trafficking, possession drug trafficking. Understand the charges. Mr. Shepherd acknowledged he didn't find like one more even and including not being able to determine not free bond. Yes, Your Honor. No complaints on your bond. You need here on August the 9th for negotiation with the Commonwealth, and August the 12th is your next court appearance. August 9th. Monday, Thursday. Okay, both of them conditions of your bond.
I know you gave me stuff from Pine, I'll send that to you. And then be here on the March.
Sherry Barnes. Sherry Barnes. Commonwealth Attorney versus Sherry Barnes, 21 CR 0036. Ms. Sherry Barnes. All companies. Do I agree?
I didn't know who her lawyer was, Mr. Smith's lawyer, I think, last time.
All right, Judge, we've got, it's a complicated conflict situation. She has two cases. In one case, she's co-defendants with Lloyd Smith and 3 or 4 others. In another case, she's just co-defendants with Lloyd Smith. I'm gonna have to submit the entire group and let people above my rank decide who to keep and who to send out.
Are you gonna elect Mr. Commonwealth Attorney which one of these things you're gonna try?
There's no resolution on trying her case, which is co-defendant for just Mr. Smith.
I'd suggest you submit that one up.
Yeah, and at this point, I'm not sure how they're gonna wanna have it, to be honest with you, because I'm not sure how I've looked at it extensively.
We be ready to negotiate the cases on August 9th.
I was, yeah, it's gonna be submitted tomorrow. So there was some conversation about private counsel. I was kind of
21
giving.
CR 0036, 21 CR 0048. Shall, as Commissioner Bond, you shall appear here at the Clinton County Courthouse on the 9th day of August for the purpose of negotiating your cases. And also, your next court appearance will be on August 12th. Now, if you negotiate one case and the others are included in it, I would assume that you can sign waiver multiple representations on those other cases. Do you agree with that, Mr. Stockton?
I do.
Okay. She'll be here on the 9th and the 12th.
Thank you, John.
Charlotte Dawn Barnett. Is there a warrant out for Miss Charlotte Dawn Barnett?
They had it on July the 8th, drug court meeting, and I was unable to attend because I had a pre-call. I don't know the status, and I meant to phone call Mr. Strauss, and he was not, he's on vacation, so I was on to. She is the big.
Pass over, she needs to be redacted.
I will just include it.
So pass over. Randy Bailey. Commonwealth versus Randy Bailey, 21 41 CR 0018. Are you Brandy Bailey? Okay. What's your year birth, Mr. Bailey? 1985 would be your year birth. For the last 4 years, it's supposed to be.
Your Honor, she had private counsel in district court, but I think that relationship is no longer in place, so. Well, it was Mr. Collins, but I. Yeah, I think her case came through district court. I thought, I may be mistaken on that.
Did you have an attorney in district court? As opposed to you did have an attorney in district court? Well, he no longer.
No.
Okay, well, has she filled out forms and everything? You own any property, ma'am? I can't hear you.
No,
Okay, are you presently employed?
no,
Why are you not employed?
my brother's disabled, I help my dad.
You what?
My brother's disabled, I help my dad.
Okay. Well, we'll get you to sign a statement to that effect here. I'm going to want Mr. Shelby. Here, the purpose of arraignment, the grand jury of Clinton County has returned indictment charging you traffic in controlled substance first degree and possession of controlled substance first degree. You understand that? Okay, ma'am, are you okay today? Are you in influence or anything? I'm just asking, you just appear to be a little.
Well, I didn't know David wasn't my lawyer anymore, I'm sorry.
Okay, so you're near because you're upset, not because so you do understand what's going on. And you're to meet with Mr. Shelley, you come back here on August the 9th for negotiation of your case, and then your next court date is on August 12th. You're in the same conditions as your bond, you will, okay? Okay, I need to go ahead and formally arraign her, I guess. You acknowledge receipt of that way form where you arraign it, or do not, you will show no pre-trial motions.
Yes, Your Honor.
I don't know if they're hands you there or not. Nicholas Brewer. Nicholas Brewer.
Your Honor, he's incarcerated. Honestly, I told jail history, he's not due out till November, so I would ask for a December pre-trial.
Dan told me he'd be out quite a bit earlier.
I'm not told on something.
I may not be able to on him, then I'll find out.
Have you here?
What we wanted?
Yeah, I would ask, I want to warn on Mr. Brewer, so we can place a hold on him and have him brought up here. There's some confusion. I know what the jail's told me, and his dad's saying something different, so I want to know.
That's fine.
Yeah.
You should have been sworn, no bond. Unless he's administratively released for the court. Very court. Combo versus Connie Lucille Brown. Are you Connie Lucille Brown?
Yes.
You're here today and your attorney, Mr. Cross. This is 21 cigar 0049. What's your year of birth?
14.
The last 4 years of social security. And you are charged with promoting contraband. Here's purpose of arraignment. Acknowledge the identity of client, what formal reading and arraignment into not guilty.
Yes, sir.
You received a copy of that.
I do, yes, I do.
You'll be back here on August the 9th to negotiate. August the 12th is your next court date. Both those days you have to be here. You understand that? Okay, okay, see. Sarah Ann Cash.
Right.
Your wife.
She's a lawyer.
Serene Cash, Serene Cash. 21 CR 0049.
Your Honor, this is a case I thought we had settled at settlement conference, but apparently that's not the case. So I guess we need to set a trial date.
What has changed?
I guess the defendant's mind, or mindset.
What was off the thing?
She was prepared to accept. It was 7.5 years and then shock out after 180 days in the drug court. I will say for the record that the evidence is going to be tough to overcome the trial. And it's against my advice to proceed the trial. Your Honor, I would ask for a little bit more than mid-August. This is not one I was expecting.
Have October 5th, October 5th and 6th.
That's fine,
If your phone ever changes, you let me know. You want to set a pre-trial judge?
No, we're in the pre-trial case. They're not going to be, after we complete it, let's go to trial.
You need to stand on that.
Now over 92 answer. 12 CR 0007. Probation limitations.
On this probation revocation violation occurred a long time ago during COVID. And I'm waiting on the co-defendant in Cumberland County. He was plea, it's not. And if that case goes the way I want it to, then I think we can dispose of this, her case and everything. Here, we'll just pass it along.
So this is 12 CR 0077, 13 CR 0012, 13 CR 0014. What date you want to put it back on?
We just put out August 12. So
August 12th. Back August 12th. Luther Conic, no one was Luther Conic. Luther Conic, 1 CR 0034. Luther Conic. Yes, sir. Born in 2002. Last four digits, social security, 04027. Your date of birth, running, representative Shell. Possession also first charges. Then you gotta share the charges. You share the knowledge and then you might see that more than yes, Your Honor. You know, August the 9th, negotiation, August 12th. Commonwealth University, Joseph Scott Cole. Joseph Scott Cole. Was there a plea originally planned on Joseph Scott Cole?
there was a Luther Conic.
Not trying to pass over.
I didn't realize it was already finished.
It's conflict case for me. I'm gonna have to get conflict counsel. He says it's my higher counsel. I'm one of those two things. We're gonna have to go to jail as part of 4 years.
Please accept it, but I'll take note of that. My name in the system.
I mean, this is a pretty common version.
It was.
It was.
Joseph Scott Cole. 21 CR 0016.
He's not here.
What? Yeah, yeah, 58 last one, 9 he's putting in Scott. Joseph Craig. Joseph Edward Craig. Joseph Craig, 20 CR 0073, 20 CR 0077, 21 CR 0041, and for Mrs. Craig, 21 CR 0021. We're ready for a pre-trial on both these individuals that previously signed. Whether you know representation, they're right, check and see if they're in file.
Your Honor, Mr. Carroll and I have not spoken about these cases since we got the ruling on the motion to suppress on June the 30th. And Mr. Carroll and I would both like to have an opportunity to discuss all three on August 9th. And if we can't get a resolution, set a trial date on one of them.
Y'all be back here as commissioner on August 9th. Negotiate your case with your attorney and Commonwealth. Your next court appearance will be on August 4th. Okay? No. We're going to move on to it. Yeah, that was See that? Yeah.
Yes, sir.
Commonwealth of Kentucky versus back on the record. Back on the record. Commonwealth of Kentucky versus Ronald Daniel. Commonwealth of Kentucky versus Ronald Daniel, the UNCR 003. Ronald Daniel.
Yes, sir.
Born in 1985.
Yes, sir.
The last one is 0403. Y'all already agree with this case?
Your Honor, we received an offer from Mr. Stockton. I explained that to Mr. Daniels, and he's considered that and wants to reject the offer.
Well, Your Honor, I would like to say, probably, he was co-defendant with Commissioner Connor, who just previously walked out the door. He's also co-defendant with Ricky Jones. So I'd like to set them all on time and pound together, because all I was saying set of facts.
Yes, and then August.
So they should all have lawyers on the 12th, like I said, 25.
You want to negotiate with them? Now, so we'll come back. I got it was a speedy trial, and they're going August.
Your Honor, is that 9?
Or seminary.
I just
heard.
Yes, sir.
I don't know what COVID's going to do.
We understand that.
Going to invade us, he was going to bomb us. I don't know.
Yes, sir. Thank you.
Virginia Daniels, come on versus. Virginia Daniels. Come on versus Virginia Daniels, 21 scale digits and 3. Are you Virginia Daniels? When were you born?
1984,
Last 4 years of social security.
796.
You're here first. Lorraine, Shepherd. Congratulations, Simon. Ranger of Clinton County. Return to indictment charging you. The criminal possession of the forged instrument. So that charge. Mayor. Now, we're getting the type of city indictment, what is one more reading, ranking,
Yes, Your Honor.
Your Honor, has been arranged to be back here on August and that negotiation will be faced back in court here on August. But both of those days are conditions in mind. Okay? Josh Davis. Comma versus Josh Davis. 21 prisoner 40. Are you Josh Davis? When you were born, Mr. Davis, April 4th, 1990. One of the last 4 years of social security, 73. Okay. You disabled the purpose of the arraignment, everything else.
Governor Robert Stevens for Dustin.
You have right to the south. Grand jury of Plain County, charged with theft and all making part of the $500 or more. It's just a drug. Charge. Counselor, do you acknowledge the identity of your client, receiving indictment, waiting for reading the arraignment, carefully not moving, certain operating motion?
Yes, Your Honor.
No complaints on the bond, we back here on August and that negotiation, August 12th, for pre-trial.
We've had some discussions, and I have to furnish Mr. Stevens some additional discovery, but we do this with September pre-trial.
We had a sexual negotiation.
No, but I'll get with Mr. Stevens. It's very good music.
September.
No, thank you, Your Honor.
Carl Hamers, John Diamond.
Just on this one, I just wanted to see that he was right.
This was pre-trial.
Yeah.
They said a run on the night, so. There should be, you can cross your ring.
We've already got.
Really?
Yeah.
Thank you.
John J. Diamond. He's on his swim on CR. Range of the Russian and South, range of Clinton, attorney, and diamond, charged with operation. For conduct, secondly, criminal first for assault, police officer. 2 counts, 3 counts, criminal issue, disarmament. Acknowledge the identity of the crime.
Yes, Your Honor. Wait for him, reading here, please, and I'll go.
Yes. What's the deal here?
He was,
Get up here, y'all move.
sorry, he was
All this,
multiple altercations with police officers at the hospital and attempted to get his weapon from the police officer. So
what's the bond in this case?
all I know is he's gonna have to be around under any other conditions.
Pre-trial on there, what is the condition of this bond?
You say his name was John Diamond?
John Diamond, what is it?
I'm looking, hang on just a second. He's supposed to be on home incarceration, no driving, subject to random drug and alcohol testing, not to violate any laws, and make all scheduled court appearances.
So he's on in-home incarceration. House.
This is pretty well, got his nose busted, we've got pictures. I mean, this is the case where probably the court have been aware what happened, probably wouldn't be out. Yeah. Okay. I just say that we'll set it for August 9th and August 12th. If it's not resolved, we'll ask for speedy trial.
I'm going to tell you something, Sharon, if you listen. If I had known the details, you probably would have got on that accusation. If you do not want to violate this bond, I will not, okay, you do not want to, I'm just giving you fair warning, okay? I don't want to be mean to anybody or anything like that. And I take very seriously anybody turn off. So listen back, you want to be on negotiations? You do your time, August and that for negotiations. And August the 12th, the next court day, in both of the conditions of bond. Okay? Carlo versus Randall Dickey. Carlo Kentucky versus Randall Dickey. From on Seattle, Randall Dickey. It's a, you got a person, Randall. Trying to show you right on the side. Very, okay, turn that. Intoxication, double substance, alcohol, food, alcohol. You have a copy of that. Yes, Gary, I would see that, and then, formal reading, and do not go to the. Yes, ma'am. You can plan on buying this individual, not, so, we'll be back on August and that, negotiation, August first, next quarter. Okay? I mean, that's fine. No. Like that. No. I'll be saying discovery. Miss Hayes, we're going to do the investigation.
Yeah, in December, she's a co-defendant with the Boomer Town woman's in jail in Tennessee, so we can just get, she lives in Missouri now, so. we can see her.
Missouri. Welcome back to Carmel. You want to come back here for December 2nd. You need to get make sure you get the phone number of the attorney. She knows how, she does a good job staying contacted. So, negotiations. I will tell you, since you were here, unless we have something that's really moving, next time I would object to her hearing Zoom. So she would have to drive back and go something about. Okay. Thank you. So hear that. Gregory Lane. I'm going to tell you versus Gregory Lane, 21 Scenarios.
This year you were,
1989,
last 4 years of social security.
so now,
You're ready for us, you know, you're the council. Your right to inside grand jury, Clinton County Attorney got to show you the criminal abuse of child first degree. 12 of charges. You're probably that.
I've not seen a copy of that, you know.
You have a copy of that when you're stopping.
We've got one file, it's, it was, Judge, I think I've got one.
You know, it's been, you might receive that, but it's already.
Yes, Your Honor.
Sir, you need to come back here on August 9th for negotiation with the county and the county. The next court date is August 12th, and you're clear to the trial, okay?
Will both those be in that, Your Honor?
We'll assume that.
Or assume that, yes, all right, thank you, Your Honor.
Partner did a wonderful job for you.
I heard that you did well, and I hate that I missed it. Thank you.
I'm over there versus Kevin Williams. Howard King versus Kevin Dale Haddix, 15 CR 001 Haddix. Yes, sir. More than that, you see. Yes, sir. What do we have here?
Your Honor, this is motion to predicate on film case. This step of negotiation. Tomorrow, Mr. Cross and Mr. Haddix, if it's not resolved, I'll be getting the trial date on the criminal motion day and consider the motion.
Otherwise, I say this for August 12th, there's a plea over there. All right, we're not approving, we know this is the dates of the trial. You back here on August 12th.
Your Honor, I thought it was a word. Mr. Haddix's father, unfortunately, was very, very, very poor health, so we plan on being there tomorrow. But he's that bad. So we'll let him start.
So that, Mr. Cross, will be all in favor.
Pamela versus Sherman Ray Hughes. Pamela versus Sherman Ray Hughes. 21 CR 003 Sherman Ray Hughes. Born in 1972. Last 4 years of social cases.
Your Honor, he's got 2 indictments. One, 21 CR 38, he does have a co-defendant, Lloyd Smith. And that's, that, although that's only a 2-person co-defendant case, it's more broadly connected to several other defendants, and that's why I'm having to submit consideration as to how we're going to.
Which one of these you gonna elect?
Probably right, on the 8th version, this is correction, first reading, first opinion, PSO first.
That's one you got to
Yeah, the other one, that.
What do you want to do about this?
Well, will he have, you guys in council all this tonight?
That's my goal.
You know, you be here for negotiations in the 2 cases, which are 21 CR 037, here on August 9th, the negotiation, here approved you, well, I will set a file. And of course, as soon as we move on, okay? Ricky Wayne Jones. Wayne Jones. This last one is here today for pre-op conference.
Your Honor, he's a co-defendant to Mr. Cotter and Mr. Daniels, previously, and also Ms. Dean, who was sentenced today, who was my client. Ricky, I believe I know who his attorney is going to be. I think we've already got that assigned, but I don't want to say so because I don't know if he's accepted. So,
You know, August and that, the negotiation, August. Cody Keith. How versus Cody Keith? How many stars are you? Yes, sir. On that DNA, yes, sir.
Your Honor, the Commonwealth has made an offer. It's a diversion offer. I've asked the Commonwealth for a misdemeanor offer. I respect the diversion offer, and I think Mr. Keith does too. It's a tough choice, but he does have, I think, a defensible case, and he's choosing to reject that offer at this time. Judge, I would say we do have a little investigation. We think there may be a witness out there who might be very pertinent that we need to find and speak to. First, we need to identify and find.
Well, that's September 1st. Thank you, sir. September 1st.
We do August the 31st and September 1st. We got a meeting, next meeting between the second. Can we get another date?
Is that something that's called? Sarah Jack.
I'm looking at meetings tomorrow.
It's very good one day schedule now.
Yeah, because I'm afraid to do it.
21st and 22nd.
Your Honor, that's cutting it really close to our food trial. Should we go maybe around that same time in October?
Did you say August the 4th? Yeah, that was something I planned a year ago. You take that. Get in trouble. That's one of the second.
6:03.
It is. I'm trying to keep that September 2nd, 3rd open so we can negotiate. No. How about putting it as a backup to the, let's see. Well, you've got, did you set Jennifer Stockton?
That's a backup.
Yeah. I was going to do this on the 27th and 28th and Jennifer Stockton, 29 from 30. We could try to put them back.
Judge, let's court the calendar, first off, I think we might be involved in the first option that week. Right, but I've done two district court trials in one day, but. Well, I know, but those are different. You know, those are different deals. Not that, no, I just, going back to back like that, yeah.
With all these class D felonies, we won't, it'll be 10 years if we don't do some back to backs and obviously some conflict.
Well, no, we don't have conflict counsel. That's not. But I'm not sure fall break and then, but mid-October, that's maybe the week after Ms. Cash's trial.
Instead of lawyers, these people are investigating, they're supposed to be filing people that are investigating, it's true. But today, I've taken up virtually every trial that's available before the judicial circuit. Whether it's in tier, once you got these people that are getting these plea offers, they agree they're gonna take them, come in here and don't take them, or they get one where they can walk out of here because nobody takes food on the guy's case. So we're gonna try some cases and let the jury decide what they want done. So I'm gonna schedule this case. If we have to do them back to back, we just have to be ready. Okay, October 56, back up campus.
And then your number is still good. Give me your number.
If y'all are together, you can sit in groups. If you're not, you need to move away from here and sit next to you. Charles Day versus Michael Keith. Charles Day versus Michael Keith, MCR. Your neighbor versus one, you know, the right hand side of the council, you know, you want to ask yourself, right on side. You know,
We've been rain.
we not had so. That's running. What are you? We'll be here on August 9th for negotiations. Be back here on August 12th.
Carol, with my understanding, from Fort Hays, there's another individual entered guilty plea today. According to Dave, he's going, as part of that, he's going to testify. I don't think. Seemed like an agreement out of that. I just wanted to have access to the agreement, but he says they don't have to have one. And all the believers.
Timothy Kelly. Timothy. He should go somewhere. You'll be right. Yes, I'm going to get you out of the Charlotte. Charlotte. I want to see how I do it.
Good morning, Your Honor. I represent Ms. Coleman. I do not have a copy of the
You have a copy of that, Mr. Thompson? This is 21 schedules, which is income of the Yes. And you're the first one. The impression that what's going to instead of one opponent. Grand jury of Clinton County attorney charging you with all this position. More than less than Mr. Carroll, you acknowledge and did you might receive that one more reading.
I do, Your Honor.
I signed a reciprocal discovery order. Discovery stage should be back here on August 9th. 4 hours for negotiations on the case, and it's August 12th. Now, is the discovery luminous? What time is that?
We're on. Mr. Carroll May wants to see that we'll deliver to his office tomorrow. It's a pretty good size box.
Well, I will tell you, once we take a look at it, it's on the CD there. If you want to push it.
Well, that's the grand jury. That's the CD, Your Honor. I would suggest we push this out to 3 months for the pre-trial.
For years, I always would.
I'm more conservative than that. I'm more conservative.
I know near those reasons.
Let's set it for the 9th, and you can request another date, and I'll have another date within in September. Okay, that's all.
Now you, Ms. Colville, your attorneys in the city will start reading this stuff. August 9th, negotiation, August 12th. Next week. There are no complaints about her bond. She can stay on the same bond. Rebecca Major. I'm on versus Rebecca K. Major. 21 CR 066, Rebecca Major. You won't speak up because you will get it in that. What year were you born, Ms. Major?
1994,
High school division, social security.
1335.
The year they were purchased for rain. You have a copy of that in this case? I do. This Major, the Ranger of Clinton County, attorney indictment, charged you with possession of drug paraphernalia, possession of marijuana, possession of controlled substance. Unspecified, possession of those substances. You understand what charge?
Yes.
You acknowledge your seat in indictment that didn't find one for reading agreement. You're not guilty of motion. Yes, Your Honor. Okay, no complaints about the bonds, and you stay out on the same bar and be back in the office tonight, negotiation. Commonwealth, and be back for August 12th. August 9th. Won't step away from this. Combo versus Rodney Nance. Combo versus Rodney J. Nance, 21 CR 002, Rodney Nance.
Yes, sir.
More than that to the city. Last 4 years.
324.
Should we represent Mr. Nancy?
Yes.
I like. You want to agree with that on this one?
I don't think we ever had a negotiation.
We did, and Mr. Manis was in custody for his arraignment. And his bond paper that he had said the 15th, it may have been said verbally during the court appearance to be there on the 8th.
Okay, August 9th. Here for negotiation, August 12th. Okay. No complaints with the bond. Here in the city. Kenny Joe Mason. Commonwealth versus Kenny Joe Mason. 21 CR 067. Kenny Joe Mason. Yes, ma'am. Rain, is that right? Mr. Shelley, what's your mind?
Maybe it was.
Mr. Mason, you own real estate? No. Your car?
Yeah.
Owns car.
$3,000.
Your job?
Yeah. Not so far.
Well, I'm going to appoint you as well. I'm going to be a private councilman. I'll reserve. Only appointment papers, I'll reserve for the charge. Mr. Sheriff.
Kenny Mason. I'm not sure.
Grand jury of Clinton County, Marion Lodge. Art, $500. Some of the charges. Now it's a new, might see that.
Yes, Your Honor.
Then you come back on August 9th, negotiations. And then we go back in August 30th. Remember, if you bond, make sure you check all the information you have. How long will you work for me in May? Matthew A. May.
I submitted it. We over. Government said that.
And 41 years. It's on Shannon J. Watson, Mercer. Gail. Shannon Gail Mercer, 20 CRs over 34. Mr. Mercer, that's what we just social security number 5655.
Your Honor, we await court's ruling on suppression motion about the matter of brief issue of operation.
Yes. Mr. Krause thought I'd give him a word. Yes. It's in me. I haven't pressed it.
Okay, I'm on schedule for August 9th. Well, now that you get through. So you're on 9th. How about Kentucky versus Red Wing?
Yes, sir. Paperwork on that. Yes, sir. Brett Wayne Murphy, 5'4", 81. Yes, sir.
Motion to continue the situation.
Yes, sir. No, sir. Yes, sir.
Same person.
Yes, sir. No, sir.
We discuss the charge of the attorney. Fully advised that your case.
Yes, sir.
Satisfied with the attorney.
Yes, sir.
You have certain rights.
I understand. Yes, sir.
you know, we had usually, we have reached the end of the document. I have not been on that. But if I decide to give you more time than that, you can drop it. There was just a motion without having the right to do that. Yeah, promise you.
Yeah, can I speak with my attorney?
Absolutely.
Okay. Yes, sir. I just want to get these.
Don't just listen to the carefully what Mr. Stockton is. Mr. Stockton.
Your Honor, Mr. Murphy has agreed upon pleading guilty to flagrant non-support. The defendant shall receive a sentence of 3 years, pre-trial diversion for 5 years. He shall pay support in the amount of arrears in the amount of $11,064.24, the monthly rate of $202, plus an additional 98. Excuse me, I misspoke. He's paying current support at $202 a month and 98 towards the arrears, for a total payment of $300 to be paid to the child support office. First payment being made on him before August the 15th. And he has a minor child that should be emancipated within the next year. When that happens, his arrears, the total payment of $300 will go toward the arrears. He'll receive credit for time served. Also, Mr. Cross wanted to put in there that if child support reduces the amount of arrears for any reason through an audit, that he'll get credit.
This is pre-trial diversion.
That's correct.
Okay, pre-trial diversion means that judge will be guilty of pre-trial diversion. And if that's the case, I will do something that's nobody see the person. But in that case, we were looking to get the felon, in the sense that the felon to enhance, but I say it's successfully moved. Dismissed the trial. I will accept the trial version. What other, if you need to report probation? I'm going to talk to you, get this information. But I didn't talk to you. Thanks. Some talk with probation policy, information. Okay, good luck.
Thank you, sir.
Your Honor, you failed to verify.
You are.
You failed to verify.
Yes, sir. And my initial.
Okay, Adam A. Myers. Are you Adam A. Myers? Are you Adam A. Myers?
Yeah.
Okay, go
I had 4 eye surgeries and
Are you having trouble hearing?
no.
I'm first Adam A. Myers. 18 cells, you represent Mr. Shepard. Maybe, well, I'm glad somebody hurt.
Yes.
Yeah. That's what it is, both, it's Social Security number
2664. Do I have a agree?
This is a revocation issue. I think it's boiled down to restitution.
It's, she had a 5-year sentence for trafficking and controlled substance for the first, she was on probation since 2019. Looks like she had quite a bit of substance abuse problem then, but she's not had any problem from that since 20, which is good. But she owes $655 in restitution, and she's not made a payment on things.
It's a lot of money.
Looks like she paid $100 on November 13th for 2019, and she owes $655.
Your Honor, she does have a disability case pending. She has representation in that, so I'm hopeful that is.
Tom Carroll.
She's experiencing some health issues with her eyes and ears and got another surgery.
No, I was in Lexington Rehab, almost a year. The chronic hit one thing.
You're not drawing disability?
No, not yet. I was in Harvey also.
I don't want to, I'm not trying to pry what
Yeah.
your conditions are.
I think she got some stimulus money or something.
You need some.
I didn't get things.
Or is it that sunlight? I'm just making kind of a joke. This was when I started racing 30 years ago. We lived in satellite. It's still like a little election made by the satellite. 30 years ago.
And also,
43 years.
Election satellite is 30. Started right before
Your Honor, she thinks she can pay $25 a month for now, but hopefully she can come into a lump sum and wipe it out all at once.
You accept 25 a month. You pay 25 a month. Yeah. You must have a good case for Tom Carroll.
No.
Do we want to set another date? No, you generally pay the $25 a month. You get that lump sum, don't do it like you did COVID money. You're gonna pay it out. Mazeka Sunshine. Hours, so I'm just going to. One or two young ladies. State your name.
Washington, Sunshine.
And be allowed in
Washington, Sunshine.
this meeting.
I think all this is all from first grade, looking at my motion.
Your Honor, we have the agreement for the court to consider.
I'm still born in 1985.
Sir.
That's for your social security, 1603. Motion in here says that you wish to, please, is that correct? Are you currently influence drugs or alcohol?
No.
Is this free and voluntary movement? Are you the same person? And the same person named in like 1 CR 0052? Was a judgment prepared in the way? Have you had plenty of time to discuss it whether you determine or satisfied with advice? You believe that you're fully informed about the case? You understand that you might have to be able to certain rights in the United States Constitution. After you read those rights, you make sure you understand the right not to testify against yourself and the rights to be not here. As a judge of the council, the three trial right, you know, constantly always talk to the parents, you know, consider always every process is and it was an hour to understand. If you're going to go to the day you up with, like, when you consider Commonwealth's recommendation, I can send you email form is allowed to law. However, I send you more than you agree to.
understand that? You understand that? You do not? I think she's saying.
Yes, sir.
Okay, what's Carmel's recommendation?
Your Honor, she'll plead guilty to trafficking, controlled substance first degree, and she'll receive a sentence of 5 years, probation for 5 years. She's got 16 days in jail, she'll receive credit for that, and she'll receive social service commission and follow all recommendations.
Has anyone, including your attorney, threat or you promise you to make this clear? You're gonna have to speak up.
No.
Okay. And are you pleading guilty because you are guilty for no other reason?
Yeah.
Okay, you understand that you're guilty for that any future convictions will can be enhanced for us. You understand that? Okay, that's your signature on the motion operator. Now, except for your Lord recent investigation, we're going to the base of the role. We'll be back here on August 12th. Which is, what was your signature on here? Okay. All right. Ricky Wayne Purdue. Ricky Wayne Purdue. Yeah, all right. Okay. Bobby Ray Phillips. Come on, to Bobby Ray Phillips. This is our person for you, Bobby Ray Phillips.
Yeah.
We do, Judge. Phillips, what year was born?
Yeah. What year were you born?
For the last 4 weeks, you started. The motion is in the decision. Is that correct?
Yeah.
Are you currently late? Listen, look here. You're the one that you should be interested in buying. Okay? You make it through life. Okay? Are you currently under the influence of drugs or alcohol?
No.
Are you the same person that you indictment of the OCR?
Yeah.
Have you discussed this matter with your attorney or satisfied with this advice?
Yeah.
The evidence Commonwealth has against you in the full form. You don't have to enter a guilty plea in this case. You have certain rights and protect the United States Constitution. Or I can accept the guilty plea. I need to know that you understand. You have the right not to testify against yourself. You want to make the same. You'll have to speak your own jury like you would in the council hearing about. But I'm going to possibly know what this politics about against you. You right to say it's all this process. Issues, you know, that's in the but those matter how court rules are sure understand that. Yeah. Okay, but here you go, please, you submit yourself to the court on it, finding numbers about a lot. Look at how much you raise all that you draw. You'll have a trial. You don't agree with it. What's Commonwealth's recommendation? Y'all move your rest will get Mr. Stockton gets out of the building. I guess the microphone's covered, probably one of the problems.
Your Honor, in 20 CR 90, Mr. Phillips will plead guilty to criminal possession of the fourth instrument, second degree, and PFO second for a total of 10 years. In 20 CR 54, he will get the trafficking and controlled substance first degree, first offense, Class C felony, receive a sentence of 12 years. 20 CR 55, he will plead guilty to tampering with prisoner monitoring device, sentence of 5 years. All those sentences will run concurrently for a total of 12 years. He served 179 days in jail. He'll get credit for that. He'll also be supervised for 5 years. He'll enter and complete long-term treatment. He'll pay restitution in the amount of $765. I think that's all we include in electric, with a 5% clerk's fee with the restitution order attached. And he'll also forfeit any interest he had in the ammunition holster that was found, and all contraband in this case will be struck.
$155. Certainly, almost $30. My variation. Now, did you understand what the Commonwealth said there? That's what you agreed to? You do it in your own free will because you argued. You understand that by doing this agreement and pleading guilty, that you will be convicted of felony subject to having these sentences in the future case enhanced. And the persistent felony could already get more time. You get another felony, you understand that?
Yeah.
Okay. Is that your signature motion? But your signature is signed up for, is that correct? I accept the agreement subject to the recent investigation report scheduled hearing on the sentencing on August 12th. Okay? Thank you. That was on 20 CR 054, 20 CR 055, 20 CR 00. Next is 20 CR 001. If you are together, you will sit next to each other. If you are not together, you need to do some space in between you right there. So if you're together, you can sit right next to each other. If not, you can get some space. Carlo Kentucky versus Ricky Phillips. Ricky Phillips, yes, sir. This is 20 CR 041, born in 1945. Yes, sir. For the last 4 years, so 3824. You're here today, you represent the council. This is pretty common.
We've had discussions about this. I need to meet with Mr. Phillips here, August the 10th, this council, and then
August and that.
no, August the 10th. She may have a conflict on the 12th, so we can do him in September. That's all right.
You take the confidence.
We want to meet with him on August 10th anyway, and then we come here on August 10th. And we can come, we can be back there in September.
Judge, I have one of them. Would you mind to take you down to Tuggle? We have it resolved. Aaron Wayne Tuggle. Mr. Tuggle? No, Judge, they're not. He's not.
Commonwealth of Kentucky versus Jesse W. Phillips. He might be outside.
I was checking her.
Commonwealth of Kentucky versus Jesse W. Phillips. When Jesse W. Phillips. This is 21 CR 0017. Phillips for the last 2 years. It's 8876. And you're the yes, sir. The grand jury, looking inside, the questions that back in your room. The grand jury, Clinton County attorney is out. Counselor, knowledge from seeing that. Yes, sir. Yes, sir.
Yes, sir. Yeah, August, and August 12th.
You be back here on August and that negotiation, August 12th. And then we will see you. Taylorville. Comma versus Taylorville. 21 CR 0042 Taylorville.
Yes.
For the last 4 years, so screwed.
260.
And you do that on 3 o'clock.
Not after the code of ethics, the way it is, I need another meeting, check, break all that.
We'll be back here on the 9th of August for negotiation. The 9th and 12th, to be back. Okay? Cherry Hills. Cherry Hills, 1 CR 006. Those are the last 4 years. 971. And here they were 3 o'clock. And then you work down.
No, Your Honor, and, I would like to pass this amendment, number of ways for a call back, no more, because I don't.
It's this one is a bit convoluted. We have.
I'll say it really big.
When we come here on August 12th for negotiation, we are on August 12th for negotiation. August and that, August and that, negotiation. Well, your inclusions of, Portland, Shannon. Yes, ma'am. I'm over versus Portland, Shannon. 21 CR 51. Are you Shannon Portland? Yes. What last 4 years? I'm 495. And you're here then first, when you're less than south, and council, Mr. Chair. Ranger, independent, county, not, different officers and yes, sir. Yeah, we said the discovery order. You're in here August and that negotiation in August 12th. Your Honor, he's been on a curfew and I believe he's been compliant. I think I contacted Jesse about.
Might have a lot of money.
I think, well, yeah, I do. I was somewhere else in the east, we didn't know where I was guessing. Troy.
Malone. And are you still have 1012 West Ward? All right.
Common versus Troy Fire. We want to see our business, what you want. 1961, last 4 weeks. Social Security. You're ready for rain, is that right?
Yes. Yes.
Ranger, you arrived in South, which is the. Ranger, Clinton came, turned down, charged. That she didn't put on the position. No, so. You show me now, as you might see that on where you.
Yes, sir.
We'll get on that. And they show all this and that, negotiation, you know, all this, 12, when you're there, when you're sitting here, you're out there. You say, there's something wrong. Chad Scott. Combo versus Chad Scott, 21 CR 0068, Chad Scott, what year you born? 8th grade. Last 4 weeks, 961. Year date of purchase of rain. Year date of purchase of rain. The right on south, here the person. So, Mr. Shepard, not that I'm aware of. Are you gonna get a lawyer? No, I'll take a look at it. You, what was that, I'll take a look at it. Reserve it, Michelle, you stay in, temporary. Now, it's a genuine requirement, we'll get you out of all that. Wait for my reading.
Yes, sir.
And of August, negotiations, 12 August, next court date, November, your bond, Commonwealth versus Jamie Colestat. Commonwealth versus Jamie Colestat, and you want to see how what year you born, so. Yeah, one of the last 4 years. Your date of purchase of rain. You have a ring. You got a right to make sale. And you're going to turn down, so you also. Sit down. Mr. Sheriff, now is again, you find a senior guy, like on Marie.
Yes, sir.
One's got a bond, so I have to come back here on August and negotiation. August 12th. Next court date, open the issue of bond. Okay. Make sure you get it. Make sure that you come on. Someone versus Robin Jones. Someone versus Robin Jones. Yes, sir. Your name is Ron. South. You have an attorney? No. I just. One job. Yes, sir. Work myself, carpenter. Carpenter. Maybe I can say maybe start. Yes. Maybe I will charge you $500. It's Marty. Sure. The grand jury is bringing back. Also, yes, sir. Now,
Yes, Judge.
August 9th negotiation. And August 12th. Yes. Shocking, not only that, 60 days, it's working. Not only that, we're listening. How Taylor versus Jason.
He did, I spoke to him the other day, and, said he wasn't scared of that, and I'm really sure.
So, into that, this school year. We said, Jimmy Keys send them to Matt.
Okay. All right, there's another thing.
No. Right, still now on that, we would be Benjamin Smith. Now versus Benjamin Smith. It's the RJ 66. Benjamin Smith. Yes. More than 1991. Last 4 years, Social Security. 4111.
Now, Mr. Carlson, I've had discussions on this case. We ended the witness statement this morning, which I'm not. But my husband,
August 9th, negotiation.
Thank you.
Same close comment. Cowboy versus Lloyd Ear Smith. Middle name Earl. Earl. Ear. Mr. Smith, this 20 CR 035.
Your Honor, Mr. Smith has 3 cases. He's a co-defendant in one with Ms. Barnes, co-defendant in another with Mr. Hensley, and then co-defendant with 4 or 5 folks on yet another, including Ms. Barnes. So he's kind of the spoke of my conflict case on this one. So I need to make a determination about his representation or those above me.
August 9th. If you get from the 9th of August to negotiate, you're going to have to do the lawyer. Maybe look out and get Mr. Shepard, you know. Please contact me. Tricia Smith. Lance Burns. She broke out with support. Carl Kentucky versus Tricia Diane Smith. Tricia Diane Smith. She's been here earlier. Johnny Stevens. Howell versus Johnny Stevens, 18 cigar. 0059, Johnny Stevens.
Yes.
Born 1977. Last 4 years.
39.
We're here today to see the probation verification.
Actually, we had that last month, he was supposed to pay $200 for the date from last motion.
I paid 2 payments, but it was like 75 on the first payment, and I paid like 45 on the next payment.
Well, we owed about $2,500.
I think it's $200.
I don't have anything to pay on the day. I'm sorry.
What did you say?
I'll just do it. And I'm giving everything I've got left over after paying payments. Well, about 75, I mean, that's most I've got left out of my check. How much can I pay?
She said 25, and I said, all right, you pay 25.
Yeah, I mean,
You're saying you paid 75.
Well, he said it's all he had left, I don't want to do the jail.
Pay $50 a month consistently. If he doesn't pay, and have to come up here on the revocation, I expect to ask him to
He
send
split the difference. You pay $50 a month.
Yes.
I paid that, because we were working in serious now. Okay?
Yes, sir.
Okay, you pay that. I want you, if you haven't paid it, I want you to come back up here on almost 12 and bring it to.
If I haven't paid it, come back, or
You haven't paid it, come back. You paid, you go where you're going, so you pay $50 a month. Okay, thank you. Good job. Yeah. Very great story. I'm over to a great story. No one CR 0019. Very great story.
Yes.
And he said, the last one was so good.
3700.
Here they are, figure it out.
Your Honor, that he is one of the defendants with Ms. Barnes and Mr. Smith. In one of those, in the search warrant indictment where there's about 6 of them. So I'm gonna have to seek counsel on how they want me to proceed with it.
You know, all this and that. The attorney. And come back to the office. Indiana student. How about this versus Indiana student? Are these companion cases? Is that what you-
They are.
Officer called Jonathan Stewart. 21 CR 0025, 21 CR 0024. Long as that's the Stewart. Is there the boss person? You might be one of my first people out here.
I was a deputy, main first one.
I've saw him do lots of things. What we got going on here, Mr. Stockton?
Well, my intention is at this point is probably to keep these two and then the other that are surrounding. Probably not.
Well, I know this, Mr. Waller had a plea, he rejected his plea. So, and I told him, I gave him the claim out.
Well, we didn't really get that one. I know that, but
I don't want to know Mr. Stevens was gonna be sure.
yes, that was a conversation.
I never got a reply. So, I guess let's try one more plea, on that don't work, so no.
Okay, you'll be here on August 9th negotiation, August 12th for the pre-trial. I guess it was indicated someone was going to claim stash or not, or we both of the trial. Is it short end work?
That's correct.
And Your Honor, I would say Candy is due in about mid-August, so
No, she ought to take care of her case today. We can take care of this today.
she probably still be
She
coming
can
back.
lay here without any words, reason.
Well, that'd be nice, if that's the case, Jesse, but I don't think that's the case necessarily. So, if that, obviously you gotta let me know.
Okay. That is what, okay? Thank you. Karen Tuttle. Now, what was Karen Tuttle? CR 0064. Tuttle?
Yeah.
What? Some street under 1135. Here they are, pre-trial homicide,
We do, Your Honor.
motion has been filed, so it says that you wish to, right?
Yes.
Are you currently in the business of alcohol?
No, sir.
We're involved here in
Yes, sir.
the same person and died. CR 0064.
Yes, sir.
Okay. We are going to discuss this, on the attorneys, we like to be fully informed.
Yes, sir.
We review the evidence in case we believe that you are ready to proceed.
Yes.
You have certain rights under the United States Constitution, party, except that you understand those rights. You have the right not to testify, well, to make the same thing. Right, speak out with your right to counsel. You understand those rights? And by any plea, you look at that's making certain almost regulation and also applying the law and prior to accepting the regulation of prison. From what also go, definitely not see almost regulation deciding. I'm stepping your left here, Mr. Stockton, come forward here. And so, regulation.
Your Honor, Mr. Tuttle will plead guilty to driving under the influence of alcohol or other substance. First offense, he'll receive a $200 fine and cost. He'll also plead guilty to criminal mischief, first degree. The defendant will receive a sentence of 5 years, pretrial deferred for 5 years, supervised. He'll receive credit for time served. He shall pay restitution joint and several to 2 juvenile code defendants, MB and JR, in the amount of $2,500 at a monthly rate of $100 per month. Will be paid to the circuit clerk's office, with the first payment being due August 15th. There's a restitution order and a 5% clerk's fee. Also, he'll pay court costs as directed by the court to maintain gainful employment.
Is that what you agree to? Get back up here. Is that what you agree to? Yes. Okay. Now, I want to tell you that on this DUI, Kevin, partner, Mason, getting your driver's license. Yes. You haven't with you today? No, sir. They already taken? Have they already taken your driver's license? Where are they? At the house. Am I supposed to do driver's license? Do what? Yeah.
He's indicated he'll get them back up here.
Well, he's like, if somebody, is he gonna drive, go drive? No.
Not if it's gonna be suspended immediately, then I guess.
You need to call up and ask, I'm bringing them. Okay. Okay. I want to tell you that here in this driving under the influence, they say, against you in the future. It's, right now, I think it's up to 10 years. You understand that? Yes. Okay. Also, the spelling, which you prove, nothing used against you. Also, the need to you understand that? Yes. Are you ever going to this about to argue or agrees? Yes. Okay. Now, it's the serious desire of the constitutional rights of the spongy whether it's decent and I used to be the law. Yes, sir. Okay. Is that your signature on the offer, motion, offer? Yes, sir. Okay, I'm more recent investigation report. There are also certain other fees that you have to pay, and other things you have to go through to respond to again. I'm going to say, we're scheduling your sentencing on August the 12th, see if we will impose a sentence here. Okay? Yes, sir. Okay. If you don't have those back up here, 4 o'clock, hands, which turn the clerk's office. What you want. Yes, sir. Ronald Perry versus Dan Wayne. Ronald Perry versus Dan 26, 20 CR 0061. Is that your line? WAY. 164. Last 4 digits are 7935. When you're here to go on through trial, on that, you're making parties.
I need to have it settled next month. Or I've got a resolution in mind. I'm just not saying that.
Well, that means, did we look it up or did we look it down?
Yeah, I've made some efforts. In this case, we just need to do that.
So do we don't need one line now. So you here on the, well, you're gonna be a little bit like Forrest Gump. You're not gonna know what you do there with that box of chocolate. I've been doing this over 2 years. That's all right. Yeah, where you are. Yep. Thank you.
Mr. Tugger lied to you, had them in his pocket.
Bring it back in. Bring your cover back in. Mr. Jones, why is you lying? I don't know, sir. You what? I'm not sure. Okay, I'm planning you to attempt for confine him. I'll see you back here on August 12th. It's still continuing to press for the new jail. And we'll see you back on August 12th.
What's your papers in your papers? I'll get it. You gonna get me an order? She's getting. So.
Mr. Stockton, you were a lieutenant.
Hey, man. Whatever, I mean, when you take this up, what do you do?
I'll consider, the guy starts off line, then you right off.
And let's see,
Yeah, like
like,
that, stole your dollar, promise you couldn't bring it back, you like a $2 line.
Thank you.
Allen person, Donald Wall. Donald Wall.
Y'all, Robert Stevens, for Donald Wall.
Donald Wall.
Yes.
One that I can report is 40 hours, 4 days of social, 36 months. Okay, you're there on 3 hour housing. Oh, yeah.
All right, have the paperwork.
No, we're in the process here.
Yes.
Motion to the city situation. Correct. Yes, we're currently. Yes. We're the same person in back now, 21 CR 0.
Yes.
You judge the parent today. It's in excessive charge for the attorney sales by his guys. Yes. And the evidence now has been you would go on much. Yes. You have to go to this case, you have certain rights and documents. You're right, I just wanted to show you one thing saying you guys speak out here. All just like it's right, you say there's all this, those men are. But you go to charge, you understand. But in the end, they do apologize. I don't consider how recommendation. Prior to accepting the recommendation, we'll go through some investigation. And then we do not accept the recommendation, deciding no partial, you can withdraw. Yeah, I'm going to be right there. Judge, what is the comment?
Commonwealth recommends to dismiss possession of controlled substance, first degree methamphetamine, and on his plea, guilty of trafficking of controlled substance, first degree, the defendant shall receive a sentence of 5 years probated, 5 years supervised. The defendant is served 128 days in jail until a credit time served. The defendant shall enter and complete the Clinton County Specialty Program. The defendant shall pay court costs at the discretion of the court. The defendant shall remain on active supervision until all restitution after the court costs paid full and further orders of the court. And at the conclusion of all defendants' cases, the defendant agrees to have any and all contraband and controlled substance disposed of in the courts of law. Any and all personal property, but not limited to cell phones, shall be returned to the respectful owner at the conclusion of all co-defendant cases. The defendant shall obtain legal employment within a minimum of 30 hours a week until the gainful employment is obtained.
Has anyone, including your attorney, offered you a recommendation for failure in very courts? This is the way you own for your argument. Yes. Knowing your constitutional rights, all the city desires, what you guys include bills and forfeiture punishment. It's very important that in future conditions, we have an agreement.
Yes, sir.
For your sentencing and probation law officer, thank you very much.
Thank you all.
You too. That's all I have. Excuse. Thanks. Judge, can you recall the person who asked you not to? Can you hear?
I didn't expect
That better than you're doing? I'm one person, Christian, I don't see it. Police are doing the third to the Smith. You're going to drop out, let's say.
Now, when you go say that, I got a few mics that you want to put on the map.
We'll be here on August the 9th for negotiation. Come back on August 12th, the next court meeting. So you're not feeling some very good. Now, the water. That's all I'm doing. Quiet in. So there is no one quiet in. We just quiet in. Let's see what you say. One hundred city. Yes. That's what we should.
No, I was hoping to get a plan.
Yeah, that's it. Your house, you get a lot of. Let's go later out. Once the rain down, point. Obviously, for the agency. So I didn't get the rain. Right hand side. Granger, Clinton County Attorney, that was charged with you with criminal mischief or three that are all taken 500 under 10,000. Counselor, you can obviously do this Friday to see that. Yes, Your Honor. Okay, I will sit back down on that. Negotiation and on the 12th, we got a headache. I think there's not much information. Last case of docket appears to be I'm up to those Joe White. Maybe on the docket. We have the thing. 30 times 5 needs to be passed. Come over to Ricky Joe White, who starts with Ricky Joe White.
Yes, sir.
We have conference here over here. Okay, Mr. Wright, motion to do the decision this year. Yes. The same person in the diamond. Discuss this matter with the attorney about the voucher case. Yeah, so constitutional law requires it. There he is, before you get up on the outside, before it's law. For accepting the kind of recommendation. Will be then information. What's your recommendation?
Your Honor, Mr. Wright will plead guilty to trafficking and controlled substance first degree, receive a sentence of 7.5 years, probated for 5 years. He served 100 days in jail, and he'll have credit for time served. Also, he will plead guilty to pay the main insurance on the motor vehicle required by KRS Chapter 304. He'll pay a $500 fine and cost. He'll pay court costs at discretion of the court. Any non-contraband in this case will be destroyed.
As you see, we come to document. And we put here today, you know, the job, the future. I'll be coming down to meet with Rangers.
One was here. You underestimate. Wow. You underestimate. I'm honestly shocked. We had a lot of those programs one time. If you told me one part, I would say, go back to that. I know, but that's easy to have a meeting with everyone earlier. I think it's looking in good shape now. Several probably. That would be cool. But I'm about my dad. I was shocked. Yeah. You didn't go back. I'll say this. 15 years ago,
But I don't.
Not really.
Yeah.
Quite often, just, you
Well, I'm a little disappointed. I thought it was always extra hand.
I called her even when
I had Greenville this weekend. And then
Be right back. You just quit taking the glass and make them take it like you used to.
I can't manage it. I'm not even on the ball today. Yeah. Yeah, people ask me, you can do that. Yeah.
Yeah, that's pretty good.
Nancy Reagan. She has a great.
That I like. She's a good kid. Oh, see, I can catch hers out, say, yeah, I thought they'd have surgery. What time for you got? Softball's taking its toll on this now. Yeah, that's free softball girls. It's going under the ground. Yeah, yeah. He's such a good. In circumstances.
Yes. At first, I said, oh, you gotta do it.
Oh, yeah.
Okay, let's go back on the record, please. Child support. Go on here. There's the squad.
I do have 18. I'm 18.
We're gonna stop putting off on what's going on with the job. Okay. 07 108.
Your Honor, we have an agreed order.
Brown versus Brown.
Your Honor, in this case, this is arrears only, and we're gonna pay 50 a month on arrears, and we're asking 300 be paid by August 11th.
Connor versus Connor.
Your Honor, in this case, it was a motion to decrease the oldest child as emancipated, and Stephanie's prepared in order for wanting testimony from her.
Bill versus Bill.
Your Honor, we're passing that. Payments have resumed.
Clinton, child support division versus London.
Have an agreed order, Judge.
Yeah.
Yes, in this case, we're going to pay $245 a month on current and $110 on arrears. We're asking the $400 be paid on or before August 11th this year, the purchase.
Cabot versus Henderson.
Your Honor, in this case, non-custodial parents, we're going to pay $410 a month on current, $82 on arrears. We're asking that $950 be paid by August 11th.
Cabot versus Duval.
Your Honor, in this case, non-custodial parents, we're going to pay $207 a month on current, $41 on arrears. We're asking $650 by August 11th.
Cabot versus Hayes.
Your Honor, in this case, it's an arrears case. Like the single parents paid $299 a month in current, 60 on arrears. We're asking for $650 be paid on it before August the 11th. We haven't agreed order, it's Mays versus Mays. Judge.
Well, I tried to divest myself of politics. My brother, I think,
See, on these things,
no, he put a message in.
no, that's already, I'm already sketched in, things, I'm trying to slide. I prove that. I told my learning council here for a week or two, there's stuff that was bothering me. I kept getting ready, I said, I don't know, I've got some kind of conflict, I don't know about. Or something, but I lost the invitation, found the patient, I started. And I checked the drive time. The drive time is not bad.
Oh, no, I've done it basically the same direction. But I recall at one point in time, you and I had a conversation where you set forth your other dissertation for and commented that you didn't ever plan on going back there.
You know, but 10 years is passed, and nobody knows who the line. That's all, that makes all the difference in the world. I don't have to have a quarter of state police if I have any money.
But I love to see the people, interacting.
It's kind of like we having gone through the pledges as a pledge of eternity after you finish it or after you finish those things, you don't go back and watch everybody else. But I just spent, we got 2 months, I just spent 4 nights in Nashville, New Catholic. Met the Speaker of the House, the President, something, I'm just legislative conference that we ran high. This was the first convention, it was right over the old Grand Central Station, where it is, the old hotel is. I'm telling you, this is the darndest hotel. Everywhere you go, that's 640, every building, condos, looking at it. I've never seen it great. It's wild.
All those new hotels are struggling for quite some time.
Well, they got into COVID. This was the first major convention they had. But that used to be, you can sit there and be out of town. I walked all the way up there to the train station. Yes, sir. I place you really want to be. No, and the goals was, but I mistakenly got into the Fairfield Inn. It wasn't one of the goals. It was out the woods of everything. And it's right across the football stadium back in there, you have to sign it. And I got there 25,000 Marriott points. That's nothing. And the other one on the Gulf was 50. And on it's about 100. So I booked the Kentucky to go football. Great. Very good.
Did Eric bring the latter speak down there?
No, he came with me to the Kentucky session. And he is very way. He interviewed me or something. He tried to get, because that was a home court for him to go so the legislature would be public voting. And we had a good time with him. Haslam spoke for the day. On the other hand, you do this, It's funny, is those states that looked over, the Virginians that looked over the Democrats now. So are they all bummed that they were going to be about the southern legislative Congress because Republicans can go in. Louisiana still feel hard, Republican is often coming. But it's a really good group. It's not a partisan thing at all. That's pretty good.
Virginia is going to be an interesting state to watch.
This, Nora Jones, she was like confused. Players and jazz. No, it wasn't Nora Jones, it was, she was somebody else. She produced, I think she was done some country as well. I think she was one of these. She in Nashville. I think so. I think she was there in town. She had an 18-year-old daughter. You used to like Steve Warner and his brother, they could interchange things over there. It was a girl, and she put her out front. Beautiful singer, that's who it was. Then they brought a group up from Memphis, the jazz group up from Memphis. Did you ever know Mark Norris, the majority? Yeah, he was majority of the Senate down in good friend. He became federal judge. Now I went down to his district down in Memphis at big time. But strangely enough, his district includes a little area or town called Cordova. You heard of Cordova? And my great grandmother was there. And so you were the center, old.
It's one of those towns in Shelby County, Memphis, Shelby County.
Yeah.
And I think there's 5 or 6 cities in Shelby County that are the top 20 most popular cities.
Yeah. They cling on to their city status to protect their self-government cities.
Did you see the first census, county census figures yesterday? All I've seen is a map, I haven't seen a picture.
I saw Flanders going to see.
Kentucky wasn't counted spread.
Well, this redistricting in Kentucky on par with the east and west. These West Virginia populations, they're all fluctuating. Okay, let's go on record. Number. Just, this is 13 CI 00153. Coffee versus coffee. Coffee versus coffee.
Your Honor, I represent Chris Coffey. This is Brittany Coffey. Brittany is out of rehab. They halfway in Webster County, thereabouts. And they've got an agreement. I want to reduce the writing and tender it to you. They're getting along.
Should say the agreement, I put them under oath.
Okay. The agreement is the motion filed by Mr. Coffey would be passed for 6 months. At the end of the 6-month period, if Ms. Coffey has a home and her DCBS case must be reopened, then visitation would be expanded. Visitation is going to continue on the 2nd and 4th Sunday. It's been 3 hours a day. He's been giving her 6 hours. He's going to go ahead and continue to give her 6 hours on those 2 days. That'll be in his home. She'll come from Dixon, Kentucky to Dashton, Kentucky to do the
visitation. And I told him if they agreement much down the road, I would read on paper, it would. I'll have to come back to him.
Well, you raise your right hand. Swear or affirm. This more to say what you're gonna do. Is this what you're doing? Is what you're doing now? Of course.
Yes.
Can you say that? Yes. Okay, well, we'll write it down. And it's good to see y'all starting to work. We just say some, maybe you can get some more parents in the future, and I'm sure the children will get. Thank you very much.
Your agreement should go to people. Okay. Good. Thank you all.
Justice Ball versus Justice Ball versus. Okay. This is your motion.
It's my motion, Your Honor. I'm the guardian ad litem in this case for Paul Hall. Your Honor, at this time, I am requesting that you recognize temporary visitation rights in the grandparents, the paternal grandparents of the child. I believe it can be stipulated between the parties that the child has a close and loving relationship with both sides of the family. Father is not incarcerated, but he has pending criminal charges in circuit court, and he has not submitted a clean drug test since such was called for by the Domestic Relations Commissioner in 2019. He's also admitted to methamphetamine use, not in the presence of the child, but as recently as January of this year.
It's not considered.
Your Honor, the child is, I don't believe, present. I'm the guardian.
Oh, you're the guardian.
Yes, Your
Honor. So you're seeking visitation for grandparents.
So at this moment, I don't believe the grandparents are represented. They're present in the courtroom.
If I may interject, I represent the father who lives with them. So they're all basically on the same page.
I'm sure they are.
Yeah. And by the way, he drives a truck and he broke down in Minnesota, so he is not here.
The father is.
The father, the grandfather, Tim Samuel.
How do y'all feel about this?
We disagree with this. The grandparent visitation statute is applicable when the grandparents are not allowed to have visits with the child. In this case, the grandparents are directed to have visits with the child to supervise the visits which the father has. They're not parties to this action. Actually, the child is not the party, typically he's the subject of the action, so I don't think the motion is appropriate at all. The close and loving relationship is not enough to overcome the standards set forth in Walker v. Blair and the Troxel case, which gives a fit parent the right to make the decisions regarding to visitation regarding grandparents, including a Hamilton case, which is have a side to it, the Court of Appeals case, which expands that to the amount of time that they're allowed to have it. So, at a minimum.
How would you go about grandparent visitation if the biological father was excluded from the presence of the problem that I see is I have no doubt, I don't know grandparents very well or anything, but it appeared to me that certainly its purpose. The father having had some diligence and these other things, if they certainly didn't follow.
Your Honor, I do have concerns with that.
Well, the primary concern is that the fit parent is the one that gets to make the decision.
I'm not talking about, I'm not very well ruled in your favor on the law.
Yes.
But on occasion, I try to look out for what's the best interest of the child, and we don't always do that. But if we have a good relationship with the grandparents, and the father is He's excluded and he hadn't done a drug test and he hadn't done it. I'm not gonna let, sir, I just made you that off. Saying that she's a doctor, she's not in. Allowing the grandparents to visit because she has the right to do that, and that's probably where we are. Okay, so why don't you talk to them? Yes. Okay, while we're in that, we take up the next case. Joe versus Ray.
Your Honor, this was my motion to modify the time sharing. I think we just need to have the court either set this for a date or refer to the DRC for a date. So well, Your Honor, what I would ask for is for equal time sharing between the parties with the minor child. Well, based on the fact that it's in the best interest of the child, that this is a young boy, and we believe it's in the best interest of him to spend equal time with his parents.
I think we should talk these kind of cases before. It seems like it's large and it's is that right?
Well, no, Your Honor, that's not the case. I know the one you're referring to in Monroe County, but there is a different standard on a motion after an initial ruling rather than on an initial ruling of custody, but still the best interest standard applies, and we think that we can put forth evidence that it's in the best interest of the child for equal time sharing and not at least for an expansion of visitation for the father.
Your Honor, worthy adversary, Mr. Ramsey brings this motion without any affidavit, without any substantiation, without any grounds, relying solely upon the current state of the law. It does, and on occasion, and he relies only upon the current state of the law, which calls for a presumption of 50-50. But Your Honor, that only applies to the onset of an action, and these people have an agreement, that they're pretty much complying with. And unless Mr. Ramsey and his client can come in and set forth something beyond saying it's in the best interest, I don't think it merits it.
That's kind of what bothers me. I'm gonna go and see it again, so there's some underlying facts and the commission, but I don't think that you really allege that you really ought to get you evidence in this. Legislature determines this, you know, but they did leave out judges that part of the land, you know, everybody thought it was an automatic first. We actually, it's strangely enough. Oh, yeah.
Well, post Supreme Court.
Oh, we're still on the street?
No. In Monroe County.
Yeah, I know we have.
Oh, that was a different line of years. Okay, that was after I was out there.
I'm not inclined, you know, just when somebody comes in and makes allegations, that's the case, it would be disruptive to every custody agreement in order that it's an entire state. We try to meet the new standard. I don't think that's what the legislature was intending. So, Mr. Carlson probably doesn't make a good argument that you have. So you think we should
Your Honor, on the point of the affidavits, I mean, I think the affidavits are only required when you're trying to change the custody order within 2 years of it being ordered by the court. We're not asking for a change in custody. We're asking for a change in timeshare, which I believe the statute says can be revisited at any time by a court.
Well, I'll let you take some testimony. But I'm not gonna be open office.
Sure.
Sure. Y'all have anything else you want to offer?
We've not talked.
We've not gotten to the point.
Always good.
I just presume that the court will go with the law and overrule the motion. We can talk.
You know, it's like the last case, we have to let people talk. To avoid them coming back when they do come out and awesome. I try to, when I recognize that there's a problem with this, I try to get people to agree to resolve it. So I like to talk about this, and see if things have changed or things have cooled down, that sort of thing. People will try to do it. So y'all talk about this, and we'll go ahead and y'all go ahead and schedule a hearing to do some great points. And have testimony on it, and then we come up with caution, are you going to the threshold of the meeting? I'm not moving. Okay, thank you very much.
Thanks, Judge.
With no words,
Judge, Mr. Gibson is on this one also, and I think he may still be in the back speaking with his client.
Okay, we'll pass over growth versus growth. Growth versus growth.
Yes, Your Honor, this is our motion for a hearing. This thing has been before you before for a motion for hearing. It's been had a DRC hearing scheduled, had various settlement agreements put in place, but it's come to a head again. We are simply, everything has been worked out, Your Honor, except I believe there needs to be an addendum made to the property distribution. We're talking about not major items here. We're talking about personal effects. I do believe.
I think there's a good chance that we can work it out, but I'll need to be able to talk to my client. I've been trying to call her about I know. I do have her phone number, yes, Your Honor.
We don't know. There's just some slight personal effects. All the major points of she alleges that he has them.
You have a list of those?
She sent me a list, and I was working on turning that into an addendum, but I haven't been able to research about that.
Without being bound, reading out.
It's a couple of pages here. I can give you some. There are refrigerator magnets, home interior pictures, some roasting pans. A lot. I think most of the items end up being kitchen related. Okay. Purple casserole dish, roasting pan with wrap. Medium pan skillet with lid, some 5M Coke glasses, an electric knife, a mirror with 2 pictures on she said it's currently on a wall, a wooden art shelf, well, it's in the bedroom, 4 wooden ivy shelves that are on the wall. I agree with his characterization that they aren't major items. They're not like cars or sets or anything.
Remember, those items probably constitute $400. Right?
That's right, Joe.
So how much money probably client should take $150? You give her $150. Yes. Yeah. Probably the items you mentioned, not. Yeah.
Next time I come in the back room.
People bank and trust.
Second, rumbling.
versus Brown.
Your, my client told me that
It's
the,
not a home victory.
okay, but the defendant in that case has made some payments. We'd like to pass that matter.
Tax general, you read that. Now, order was on.
That's Mr. Wilkerson, Mr. Byrd.
Mr. Hurt, can you follow this case? I am. Mr. Wilkerson. You were back here. Oh, we are going to get Mr. Wilkerson out of there. No, you think it. People's bank address. County versus state.
Yes, this is the borrower in this matter was Mr. Parrish, he's deceased, and we're asking for an interim judgment and an order of sale in this matter. I have a order for, I have it right here. Order of sale should be entered.
Obviously, $200. So $200. See, I never will call them. You know, I'd say you don't propose to be.
We don't have any of this. Thank you, Your Honor.
You have a good day. Dale versus Dale.
I spoke with Mr. Cross, and he's gonna try to give me a proposal from his client. I guess we'll just have to go back and forth if we don't agree. That was shown.
Is anybody ready for anything else?
I got it wrong.
You want?
Renault. Renault. Sorry. I'll try to be louder.
This is in your own.
And Your Honor, this was my motion to set this case for a final hearing. This was before the court several months ago. At that time, Your Honor said that you would listen to the issues of property and refer anything about custody to the DRC. We had attempted to mediate the case. We were unsuccessful on both parts of that mediation. And so now we just need a hearing date, I guess, at least with the court for the property. Well, on the property portion, the main issue are poultry houses that Mr. Renault co-owns with Dwayne Riddle, who's been put in as a third party respondent to the action. Basically, there are issues with the ownership of those, equity, and the division of the property that's contained inside, as well as the debt that goes along with that. There were also some issues regarding some monies that were left over from the house sale, as well as questions about possible repayment from one party to the other on bills that were paid during the pendency of the action. And then on the custody area, I mean, there's just a full-blown custody dispute on that as far as who should have the children, what the children's best interest is.
I don't know why I said. I think you need to make an issue like that. So, check all the commissioners, just stay back on the.
Your Honor, there was one other issue I wanted to bring before the court. I hadn't brought in a written motion. There was an agreement between the parties on Father's Day, and for my client, Mr. Renaud, to have the children. He did not receive them that day. He was asking the court for makeup visitation for those children would like to exercise that time.
Sure. Well, we had any more offer on Father's Day.
I have, that's the first I've heard of it in my time in the information.
What happened to Father?
And fell on the weekend.
You know, they had on Father's Day. I understand this is happening. You know, weekends and that sort of, was the agreement specific about Father's Day?
I believe it was a verbal.
I have a verbal for a paper.
That's just something that usually put all the issue out. Did you do this at first year?
I was not along with the original orders that were put in the temporary orders.
I always put them in. So now I can get it a lot of times to someone where she worried, she would have that something. Okay, well, we won't deal with that issue, but I can bring it some other day. It's not an agreement. It's not
If you want to get this first.
Well, yeah, Harvard sale, I think there's somebody in here. They use the jury. Go to the right, go to the right. Okay, is anybody else got anything to share? Is somebody back in there?
Somebody in the conference room back here.
We'll just use that cell area.
That's back here.
We've got one crane case that come in on the road trying to get here, down the bench one on. We're right there.
Tim Kelly. Mr. Kelly, final attorney is not here. Are you representing?
I'm not. I actually promote the Reds.
What?
I actually promote the Reds. Steiner should come behind for getting Reds. Yes.
Why would you?
We do tree trimming work in the country and stuff. And this morning we were to go to the job sites. Go get all the equipment, the guy and stuff, get it ready for the mornings. So we do what we gotta do. I always try to get the very early to do it. I was just looking for trucks. One from the trucks we got to get the piece of equipment.
I cannot hear.
I'm sorry.
Speak up.
I'm sorry, like, one of the pieces of equipment I was driving this morning was one of the company trucks.
Why weren't you here?
It messed up. It tore up on me. And so while we was at working, we had no cell phone service. So I tried fixing this truck. And then I walked up the street to get enough service to call my boss, come get me and get me here. And so I did call you guys to let you know, hey, certainly no. So I apologize.
Why don't you stay around and record here and see if you can retain I'll have to come here on the night when we were sharing in the 16th. You don't need to be
plan on being out, and you're supposed to be here in that box. And I stood away all day. I didn't.
I
You
apologize.
just have to see it right over here and do it. And don't wait to get out of here without talking. Somebody else say, you finish all your things across. I believe, no, it's long, but it's not everything for now. Well, I think we're almost there. Is there any other, the negotiating companies in which, Mr. Wilkes, and I can do the board of the case. I don't wish I wanted to bring back for you.
I've tried to call her a couple of times, but I've got those messages. Haven't been able to get a hold of her.
Well, did you bring a motion to this?
I did, we're here today, just to get this thing resolved.
Why didn't you have one of these out?
How many days out? Oh, did I serve them? Oh, this was 15 days.
Where did you want to live?
She lives,
10 days ago. 10 days ago.
she lives here in Plymouth County. So Camden County.
Where do you think she lives?
Monticello somewhere, I have no idea, but I know it's in Monticello. She's a couch lived from here, from person to person's house.
I'm gonna award y'all $200. Attorney's fees. This day. She has until reach agreement. She can come back to you. Notices that. If not, she doesn't notice and you schedule something out. It's going to be related.
Okay.
Your Honor, I know that, you've been on your position on the attorney's fees, but can I just ask for leniency for her on that? I mean, I'm hearing the message that this is not something that is worth the court's time, not worth Mr. Brush's or Mr. Wilkerson's time. I think that.
What do you want me to just call or step out and not have any attorney fee or walk away free without pay?
Well, what I'm asking for is for the court to give her another opportunity to settle this on reasonable terms, and if she doesn't, then attorney's fees will be back.
You can't expect anybody want to litigate home data and things like that to reason settlement. So she's got an obligation. How did you? I'm going to order her to pay $200. Now, if you want me to keep the rest of it open, I told you that she motioned, you file a motion and come back in and give them notice and I'll still consider, but there might be something sentimental like that I'm not aware of.
Well, I should say some of these things she did list her worker dads. That's why she got.
I'm not following her out. I'm giving you an opportunity to bring it back so she can put in the legitimate claim that she has. Okay. And because, I'm not hard-hearted about this. I've got little things you want to me that wouldn't mean anything to anybody else. We all have those. So if you've got a list of those, you need to put them in the office and in a motion, and we'll take a look at those. Hopefully you can agree. Might very well be you give a reasonable list. The gentleman can provide. Okay, thank you very much.
Thank you. I will.
Okay. You all said something. What do you got?
I don't know if Mr. Wilkerson wrote that.
McWhorter versus Arnold.
Yeah, what do you got?
We got parties here.
Okay.
Your Honor, this is our motion, this is the petitioner's motion for temporary emergency custody. This was previously brought before you, Your Honor, back in March. And there had been some testimony was taken at that time that Mr. Arnold had an attorney and that he gave us the attorney's phone number and he advised us to work out something. And I contacted his attorney. There was no such attorney. And then the respondent subsequently filed a pro se motion, a pro se answer. And in which time Mr. Arnold made overtures to the petitioner about exchanging the children at some point in time. And so that was finally, there's an affidavit filed that articulates this as well. So I'm not speaking for the term or off the record, but there was overture made on June 4th weekend that the children were going to be back in the county for visitation. That visitation never happened. He pulled the rug out from under.
Just, I guess our position initially is that there's a jurisdictional issue. I don't think we can get to the substantive issues until we address the jurisdictional. There were previous court proceedings that took place in Indiana involving these three children. Our position would be, and in his pro se response, he actually raised this as an issue in his response. Our position would be Indiana has jurisdiction in this matter and should under KRS 43826, that they would have continuing jurisdiction. My understanding, and I would say I'm admittedly not the best in jurisdictional cases. I've had UCCJEA cases from time to time, not every day. Well, I was trying to create a lower workload for both Mr. Wilkerson, myself, and the court, and for some reason he objected.
Yeah.
In response to that reply, the children were living in Clinton County before the children moved to just immediately prior to the petition being filed. The children lived in Clinton County for 2 years.
Over almost 3 years.
Almost 3 years prior to the
We've been here for almost 3 years in the same house and everything, in the school.
So how did
the respondent took the children back to Indiana.
What did you say? I'll take it. What he said is not testimony. We're not sure. So they were together here.
That's part. They were together as I was in Indiana, and the children were born in Indiana and lived there. And then they moved here for, by his account, a little over 2 years. And
So he takes off to Indiana. Leaves her down.
No, that's not what I'm saying. My argument may not be much better than that, but it's a little better than that. The preceding cases preceded him leaving Kentucky. In other words, these were in, I think, 2014 or 2015, before they came to Kentucky. And my reading of 403 8.6 is it's an exclusive continuing jurisdiction issue, which Kentucky could exercise jurisdiction if they met that 6-month period with, just for the sake of argument, let's say they do. If they meet that, there's also the follow-up that the other court has declined jurisdiction, but there's been a finding that there's not much shorter. Yeah, both parties are biological. Yeah, biological parents. Yeah, yes.
Well, yes, the emergency matter, the petition was filed along with the emergency motion. Given the emergency situation in which the children left the domicile and was in Indiana with basically little to no contact between mom and the children, mom and dad. And so we needed somebody to step in, we needed the court to step in to get this situation straightened out. And so the nature of the motion is that it's a temporary motion in requesting full custody because of the dangerous situation in which Mr. Arnold placed these children by usurping sole custodianship and moving to Indiana. pose a dangerous situation and pose a risk to these children. Your Honor, in reply to the jurisdictional issues and kind of the position of the petitioner, that there's been some talk about these Indiana proceedings, but there's nothing in the file. This petition was filed back in late February. A pro se response, or pro se answer was filed many months ago. There's been no certified copies of any kind of proceedings in Indiana. There's not been any kind of act of Congress, no record of Indiana proceedings. So I think it would be inappropriate at this time to rule that this court doesn't have any jurisdiction without any.
That might say. No, so that just came here for this motion here, and to find out what's going on. I've had so custody kids since 2015, and
what situation? So what happened in 2015?
we went under a children in need of services case due to the fact that.
Your Honor, if I may, can we put him under oath to testify about things?
I'm not taking this.
Okay, I just want to.
I'm just trying to get an overview of this and now I'll get a chance to take
I know, I just.
At which time CPS got involved because my youngest daughter was born with marijuana and alcohol in the system. Matter of fact, all three of my kids were. I came back from working out of town. Was home approximately 3 days.
I don't want to know.
What happened is I was. Yes, sir.
So what you're saying is you had you reconcile who you are.
Yes, we tried to reconcile.
With the awful woman that had alcohol in her life.
Yes. Yes, sir.
Well, besides the life-changing part, and there any kind of change being necessary.
Listen, I'm a woman not. This one wants to raise the children in the end. She wants to be working there. Obviously, she had one chance. The commissioner or anybody or having hearings, obviously, what would be the best interest of the children? That's what we are. And you might have done what you thought was right, but you denied any court from being able to say determine what were the children are doing, taking need self-help. I'm not saying you have to do your motive, but now I don't know if you can visit children because what some judges will do is take them into custody and put you in jail here until the children came back and you vote it all out. You didn't bring the children in here because you thought some court might enter an order and let the mother have visitation. I don't want to bring the children. You come down here to do a scout and check it out. But I'm not saying that's not smart, well, because you didn't want to subject them. But I don't really like people that are hearing about the custody of children and down here to keep children somewhere else. Because I can get the children over, like I'm talking to the judge up there under the state contract. You can do that. But I had an old law partner that said there's an easy way and a hard way. So I would suggest that y'all go back in the room and talk about what you're going to do in the future. Because I doubt very seriously you're going to keep this lady having some sort of custody, or you're going to keep having some sort of custody, so you've got more something out without going through a whole lot of things. How old are the children?
They're 10 and 9.
Wow.
Yeah, my daughter just turned 7, my other one's
It's
Seven,
seven,
8, 10, sorry. Yeah, they all have birthdays coming up, and I was
I
also.
don't want you to say that.
Yes, sir.
I mean, 7, 8, 2. Y'all go back there, and I guess too much time to expect you to have, agreement. I want you to talk about some overall things about, obviously, you don't want to.
No, sir.
Yeah,
And I also
not
have
that.
one, my children have.
Well, so I understand that. You want to have a mother that not her, a different mother. Yeah, all right. So I understand that you don't like her, and you think she's not their best. I understand. I understand she knows that she does it. And somewhere in the middle there lies the situation. Now, I'm not holding against you guys living in Indiana, because there's a lot more people who want to live in Indiana than Indiana living here. A lot of people come, but a lot of people from Indiana come here. You're not going to get mistreated because you're not. I'm not going to mistreat you. I'm not going to give her anything. It's what we need to do is we got 2 young lawyers. You go back there and see if you can talk to you all and see what the school is and offer about what stage of hearings. And, I'm for here, before we find out anything else, since this is an emergency situation, I'd like them to submit yourself to jurisdiction court. Before it's kind of made in appearance, and you submit yourself to jurisdiction court in this hearing. You enter it, you're here. So you're subject to order this court, in order for it to be enforceable because you're here. So it might have been better to see the children down here and stay up there. Y'all go back there and work it out, see what kind of progress you can make. Okay, anything else? Any other case? You ready?
Yeah.
What do you got? I don't remember which one I sent you back.
Now, we have the grand parents come up, Your Honor, if we want.
No,
Okay.
Work out anything?
No, sir. Okay. Your Honor, may I respond to Mr. Gibson's argument?
Yeah.
Thank you, Your Honor. Hey, please, court, Your Honor, we basically agree with the guardian ad litem's motion. I would call the court's attention to the fact that this is on a, first of all, on a temporary basis. I think on a temporary basis, this court can do about anything.
Well, let me tell you what. My inclination is not to give the recommendation. But on several times, you aware the Supreme Court told me my inclination about we're not the law. You know, I don't know what the law is, and so I'm gonna give you an opportunity to respond. What is all mentioned about the statute? Because I've done temporary custody things and eating and cold after I came back, so I didn't have jurisdiction. So I'm very sensitive to jurisdiction. The Solomon thing does not seem to work too well. There's a lot of people going to go in, you know. So I'm not going to anticipation. They're not trying to certain that the husband or father not complying with the orders.
I have an alternative, Your Honor.
Well, it'd be all right if they agree to it.
Well,
Tell me if they
perhaps
want.
not going to agree to.
Well, they're not going to agree to it, they're going to do it for the law. Okay? They're going to do it for the law. If you're right about the law, and I find out that they were just in the house and not entering into it, then it will not be in their favor. You know, it's get to see the law is. On occasion, I try to follow the law. I'm just not willing to do anything unless, without giving you all time to brief those. That's what.
10 days.
15 days?
15.
I don't know.
15 days and give them 10 days to respond, okay?
Thank you.
Okay, thank you very much.
We spoke just very briefly. I think that he probably will. He's not today, but we have spoken about my potential representation. I think we're gonna be able to work something out. So I can make a limited appearance today just to pass the case on and speak with Mr. Stockton about a resolution on it.
Needs to be here. You'll be here on August the 9th with the attorney, so the negotiation. And August the 16th.
12th.
The 9th and 12th. You're not to negotiate, and the 12th is your next appearance. So you told me that you don't need to public, and you got your high price on it here, and now you get some money cheaper. But you get it.
You get what you pay for, right, Judge?
Yeah, but East Wayne County, you probably give you a special rate. I know it's $1,000 thing. So we expect to be here. Now, let me tell you something. We over here one day a month. And a lot of people have spent this time to mix them here when they don't show up. I have no doubt you're telling me. I'm thinking you are, but everybody comes up here. Has some excuse. You know, some of them aren't as good as yours. Very few of them allege that they're working.
And Judge Floyd's part, I do know his employer, he's a good friend of mine.
I cannot be working, you know what I'm saying? I don't see that working people that actually recognize it at all. So you be here on that and the 16th of draw.
Thank you. Thank you. I appreciate the call.
What we said was. Okay. I don't think so. I've told them they had tremendous problems in exchange. You know what I'm saying? And they call me. I told them, text them. You don't call. No question. I don't know. No. What oldest one came? She's young. It was bad as truth when we got to the that was last. I think
They may be a while. I'm not surprised. And I'm going to grab an order and be ready.
COVID doctor in Greece. Said how the woman was
Tell you a joke I heard. Actually, somebody sent me a skip.
Yeah. I got some on the show. I always can't jump.
I thought that little guy's up high enough blocking shot just about it.
He did. He did. Oh, he don't get it. Yeah, I don't remember that. I don't remember. That's been a long time ago. Yeah.
I remember when he met some Converse and
Low cuts. Yeah. They wouldn't let us wear them.
Yeah.
Yeah, the bottom would come loose from the sole.
You kind of, when you walked down the gym floor there, you had them Converse on you, kind of your chest kind of stuck out.
We had to wear them with the ones that had blue toes had weights in. They had the high tops with weights in. Yeah.
Them old style Converse come back, them old school.
Yeah.
They made a big comeback, you know, they wasn't
They
popular.
didn't
Now
have,
they're everywhere.
they didn't have any kind of insole. It's flat as a board. The other flat as a board inside.
Everybody done. Everybody wasn't on cash.
See, everybody, when we played Mississippi State, they're freshmen. We played Alabama, Auburn, Mississippi State, there in the way. Freshmen, they couldn't play SEC. It's all white. Yeah. I played the prelim of Rough Strumps 4 times. Conley, Cron, Riley, Jones, Jones, Conley, Cron, Dampier. Yeah. I played the prelim 4 times. I guess we got Tom Stevens. Yeah, Logan can play for me. Yeah. Yeah, he did. Riley. Yeah, Riley too. All them guys did well. Yeah. Artists. Artists, yeah. Yeah. I transferred. Jackson, somewhere, Jacksonville.
The army. The army. You get in there. It's, which is not nice. My dad, he was the war hours. He always taking over basketball. Once I've been there too. You know, they had big things. All you got to Houston, UCLA, once
King Olajuwon.
No.
Wasn't King?
One else very good.
I think he plays for you. He did. Oh, he's out. He was out. Yeah.
Yeah, well, this is. I don't use it. I tell you what, the biggest situation is, you see the way the security.
Florida has a pretty good cheerleading too.
She got on the head.
Had that looking around the small bits.
Yeah, nobody out there.
Nobody out there.
Oh, that, yeah, right.
All the time.
All the time.
I told him.
I'll have 10 phone calls to
That's been 30 minutes ago.
Yeah, we lay action, all the way through.
It's not bad. There's always something. Well, it's not bad.
Huge travel.
Oh, during the holiday, it was huge. Where? Oh, knock on wood. I look at the 4th of July and on big holidays, that little town, maybe Casey or Hill or something.
Where's the yards? Yards
First weekend in August. So it's coming up, couple of 3 weeks. Yeah, because people get up.
Wait a second, I'm gonna tell you how that was done. Johnson Baylor. UCLA Woodhouse Senior, Oscar Robinson, Jerry West, Elgin Baylor, Elvin Hayes, John Havlicek, average attendance, 18,747.
Full capacity at that time.
That'll be fine. We need to ask Sean to step out of court. June, we can split outside. Mr. Roberts said we'll wait on that, all stuff is on the previous.
Yeah.
Trey was appointed last time for the child. I just hadn't seen if he was appointed as jail for the child this time also. Is he still back here? Can we grab him? I don't know how to do He was GAL for the child last time. Collins. Wanda was, and then Wanda had a conflict, I think, because of the J case, maybe once upon a time. I don't know. All I know is my clients are born. Yes, we did one earlier this year. Oh, which one? Oh, yeah, I know that one. Sorry. I thought you were talking about the other door here, but then you with this here.
And those, no, it's not.
Kelly, we're waiting on Trey.
Okay, that's fine.
Sheriff's race. Tim Catron. Ronnie Ellis II is going to be running the district. His dad, Ronnie Sr., is the jailer. One last time around in the jailer's race. Seems to be. He won the jailer's race pretty big. Well, he beat Ray Upchurch in the primary by a couple hundred votes and then just absolutely destroyed Harvey Shearer in the general election. And he says he's not, but he says that every cycle pretty well. He was 3-term or 4-term jailer. I mean, he was really, and then he's not been able to win. Every race he had though, well, they talk like Scott Gehring is going to run again. He ran as a Democrat last time, but now he's switched parties, and he talks like he's going to primary Anderson. Anderson's announced he's running for a 3rd term. Drexel is still alive. 92 or 3, I think. He's one of our last World War II veterans. Mm-hmm.
I've been out there to Steubenville, what's the name from the town?
Steubenville's that way.
Yeah, that's what it was. Had a church.
The Steubenville church sort of up on the hill. Yeah.
Well, there was some kind of sale, personal property sale, huge crowd. So I went out there, but crowd. I didn't know anybody. I had a grocery down there. What was the grocer's name down there? That was the big politician myself.
Rankin?
Junior salvage, okay.
Yeah, 84. You didn't have many in up there in 84.
No.
You had a few. Bates.
Bates, well, I didn't know superintendent, but he and Bates were always on the same side, although they act like publicly, they didn't like each other. So I went to the steward and went to this, sale, and we crowd, that's what the hell it's, I don't know how it should be. This guy keeps following around, asking some weird questions, you know, and stuff like that. They were in Cambridge or something like that. So I get my car and I noticed he wasn't behind me. He had to go, you know, just overall and stuff like that. And I started getting concerned about something wrong. So I pulled down there and Rick's was, Western Auto store there, pulled there, and I said, oh my God, they got us following around. I said, who is that? That's my cell superintendent, Vernon Needham. You know, of course, he was like a bowling ball. You
Yeah.
know what I mean? He said, go ahead. I guess he would this, you know, stuff and everything, but he did look like a school.
Right.
British. And of course, they had, what was the guy's name that ran this one?
Donna.
Who?
Oh, you mean Kirby?
Wrangler, Kirby Wrangler.
Kirby Reed.
Kirby. Good Clinton County boy.
He said it was related to connections, or there used to be some connections over the coming. He then said that he was a nephew or something, so the answer, he'd been dead for 70 years. But I think Kirby's presence at first probably helped us.
Well, it's split that. Now, okay.
I came in second one.
You and Fryman and Kirby, Randolph didn't run that year?
No.
Okay.
Three of us.
It's three of you. Okay. Yeah, because Kirby was not viewed as a real serious candidate by a lot of people, even though he was a nice fellow.
Nice guy, but I could see why he wouldn't be taken very
Yeah, because
seriously.
he didn't do anything here.
And I tell you what, we were between Price Haggis writing stuff for Fryman and who was writing stuff up there, they burned my ass out.
Oh, but you had David Cross and Tim Purdue and Arco Dickon and Pickens Moran and a handful of others. Pickens Moran was your friend. Yeah.
And then, of course, I had, you know, shows.
Yeah, you had a good, well, Tommy J. Davis ended up being for you.
Tommy J. Davis, but then he had, well, he was calling, of course, they were crying.
Yeah.
And Hal Rogers did everything he did. Because they wrote, first thing, Hal liked the Republicans, he liked somebody on Wayne County, he really liked somebody on the radio. That was his main thing, he was in the radio business, there was special handshake. And you know, I got pretty close to him, if I didn't hear it, those reasons. I got pretty close to him, but I had all the people at the contrarians, I had
Lodge Coffee.
Jack Miller always Democrat.
Bobby and Leonard.
What was that district back then?
Well, I had Clinton, Wayne, in the lower part,
Russell was split.
Brian Rowan and the Jamestown precinct.
Huh.
And Eller, yeah, you got killed over at Eller, so. You didn't do too well. You remember it like it killed Lige because Welby was on the radio and they were announcing, and in the Bryan precinct, where former county attorney Lige Coffey led the forces for David Williams. It's Ryman in a landslide. They said, oh, Lige got some man. Lige Coffey he was one of my mentors. He was a great fellow. You got me pretty, in Eller, you may not have. Brian, you got.
Lake precinct, I did pretty well, because in a lot of movies, Jamestown, I had Elder, Jamestown, Lake, Rowena, and what was the other?
Brian.
Brian. Yeah, you see, in the legislature, I introduced an amendment to unite all Russell County in one district. And file an amendment for Overstreet sees it up there, he wakes up out of his stupor, he goes up there and files the exact same amendment. And of course, the Democrats, and they call his amendment. And Dave Davenport had on the front page, Overstreet reunites.
They all drink out of the same bottle.
Yeah. But it was fun. You know, that, I remember we had these debates in Fryman. Price had it, so it was running Fryman's campaign, of course. We had one that was on the radio, called Fly in the Hill, which you find every week, come on the radio, very long, so that worked. And I'm not so sure that they didn't call him into the station here, but they had prepared. I had this Farm Bureau issue book. And got over there and they started, and Farm Bureau sent questions out, you don't have to do that issue book. So I knew what their answers were. I don't know. Richard is, what, he's cheating. He's got the answer. I said, no. I said, no, Representative Ryan. I said, he's been up there for several years. Evidently, you've never seen the Farm Bureau issue book. I said, it's a grassroots ground up thing. I said, that's what they do. And I said, that's true. You voted this many times. Price, he was,
Oh, he's serious. Serious. Yeah. Walton won't live a week. He won't live a week.
The price was something. And, but I was looking out, superintendent, both superintendents over there. And of course, Mike Radford, those guys, are they your people?
Yeah.
Yeah.
Did you have Leland?
Well, I tell you the guy, Richard Marr.
Richard Marr.
Richard Marr, but Richard was working on one of those hardware stores on the square.
Terrell and Johnson.
He'd stick around a little bit.
Did you have Bruce? If you had Bruce, you had Leland. Was Bruce for Kirby or was Bruce for
Bruce.
Ramsey?
I didn't know him. He was really young. How old was you when your dad be now?
Dad would be 68 now.
Oh, he's the same age I am.
Yeah, what year were you born? That's when he was born.
But I didn't know him. I don't think. When did he first get involved in politics? I didn't know him until.
Oh, he ran for circuit court clerk back in the late 70s, I think.